the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated.
We'll call the first case, 25-2114, Collision Towing and Auto Body LLC versus Prince George's County, Maryland.
And I want to welcome everyone to the Fourth Circuit this morning. We have 4 interesting cases and lots of good lawyers, and it's good to be with you. And Mr. Hallett?
Yes, sir.
You're representing the appellants in the first case.
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. May it please the court, Jordan Howlett for the appellants, Collision Towing and Auto Body, and Cornelius Woods. With the court's permission, I would like to reserve 6 minutes for rebuttal. Your Honors, this case is about the difference between regulating property and taking it. For more than 8 months, the Prince George's County padlocked every entrance to my client's commercial property at 7229 Landover Road. The joint appendix at 420 confirms that fact. The padlocks were not removed when my client appeared at the property and asked to come into compliance. They were removed only when the property was sold, and they were removed only for the new owner. Joint appendix JA 422 confirms that fact too. There is a name in our constitutional tradition for what the county did here. It is not regulation, it is appropriation. And under the Fifth Amendment, an appropriation requires just compensation. Your Honors, we ask that the court respectfully do 3 things. First,
He sold this property, though.
he was forced to, Your Honor. He had no other option.
And does the record show how much money he got out of it?
The record doesn't show that, Your Honor.
Then how is there any evidence of lost value?
Your Honor, there's a number of things in the record that, with respect to the loss of value, the diminution in value in the real property itself, I don't believe there's an amount in the record that shows the difference between what the value of the property was and what the forced sale value was. It happened towards the end. Oh, sorry.
Don't we need that? Doesn't there need to be some evidence of value and what the lost value may have been?
So, Your Honor, yes, for purposes of the real property diminution in value, for purposes of the Penn Central factor test specifically. When I get there, Your Honor, I'll note that we are arguing a per se takings primarily, and the alternative taking, a regulatory taking under the Penn Central factors. But yes, Your Honor,
You said there was nothing else he could have done other than sell the property. He could have abated the nuisance, couldn't he?
Your Honor, if you view the record in the light most favorable to my client, with all inferences drawn therefrom, there's substantial evidence in the record that he abated the nuisance. In fact, I myself, representing him, sent a letter at the...
Where should you say there's substantial evidence that he abated the nuisance? Where is some evidence I could look to?
Your Honor, if you look to...
Do you have photographs?
Your Honor, there's no photographs, but there is...
Because there are photographs of the nuisance, just not of... I don't see any abatement.
Of the alleged nuisance, Your Honor. The problem in the record supports in his deposition, Mr. Woods testified that... So the nuisance is...
That he doesn't think that's his property.
It's not his property. It's not. The trash dumpster that's in this picture that shows this illegal dumping happening, Mr. Woods testified, and the plat confirms that that's not his property. In fact, there was a lot of back and forth in the deposition about the fact that his dumpsters remain behind a gate on his property, and that the dumpsters across the street are not his dumpsters, and that there's been illegal dumping happening there for years, and that he complained to the county, and so did the neighboring property owner on a number of times about this illegal dumping. Not his property, Your Honor. And viewed in the light most favorable, I think that's weighing the credibility of the evidence, and I think that's a task for the jury.
This is a federal takings claim, and there's really a threshold question of whether this was even a takings cognizable under the the takings clause because you have a nuisance. Are you familiar with a case we handed down last year, DA Real Estate Investment versus Norfolk?
No, Your Honor.
Take a look at it when you go back. I take it what you want out of this case is damages.
Yes, Your Honor.
Correct? Well, I can tell you in that case, we said it, and these are the words. If the property was a public nuisance, the city had the authority to abate the nuisance without paying compensation. You familiar with that?
Yes, Your Honor. And
Why does that not dispose of this case if it is clear that this was a nuisance?
that's the issue, Your Honor. In this case, which is distinguishable from that case, and I'll go and read the facts of that case, Your Honor. I'm not familiar with the facts, but I presume that in that case, it's undisputed.
Don't try to distinguish something you haven't read.
Oh, yes, Your Honor. I'll say,
Go back and read a little bit of it, and then come back and tell me how it distinguishes it.
I will.
Because that's just one sentence that I read out of that opinion. I mean, it goes on pretty much deeper than that.
Your Honor, let me tell you why this case is different from, let me just tell you what, there is no clear public nuisance in this case.
Well, they had two hearings. They gave your client hearings. The first one, he represented himself. The second time, he brought in a lawyer. And after each hearing, they declared this a public nuisance. They wrote opinions. I mean, I was impressed that an administrative body was doing this kind of work and writing it up. And they, my recollection, that they did declare this to be a public nuisance.
And Your Honor, you're right. The Nuisance Abatement Board did declare that. The
Well,
lower
then-
court.
And it's the Nuisance Abatement Board, and they declared this a public nuisance, and you're standing up here saying it's not a nuisance. Well, that's completely contrary to what they declared, and that's their job.
You're absolutely correct, Your Honor, and at this point, I would say there is substantial evidence in the record that the Nuisance Abatement Board acted outside the confines of the law. The lower court even says it in the opinion, that the plaintiffs...
But you're arguing that their declaration of a nuisance was erroneous.
Your Honor, we're arguing that the Nuisance Abatement Board did not follow the law with respect to...
That what they did was error. They had to be wrong.
That there shouldn't have, so they did not, so the Nuisance Abatement Board members, and it's in the record, that admitted under oath that they fraudulently signed off on requirements that they...
Wait, where in the JA did they say that they fraudulent, did they use the word fraudulently?
They were asked that specifically in the
Okay,
deposition.
Okay, where in the, what JA site?
Give me just 1 second, Your Honor.
I don't want to take up all your time. You can look for it and tell me later.
Yes, Your Honor, I'll get it for you on rebuttal.
Well, let me ask a follow-up on that, and that is, if the determination, as Judge King said, is made by the board, and this is under Maryland law as to what a nuisance is, the board made an initial determination. You didn't appeal that one at all. And then even here, where would the appeal for a board's determination that something is a nuisance be? Is that with us under Maryland law, or is it the state court?
It's the state court, Your Honor.
Did you appeal the determination in state court that this was a nuisance?
Your Honor, the plaintiffs did not appeal, and the reasons they did not appeal is they were
It's not
trying...
important to me right now. I got your reasons right now, but I'll get those. But I want to know, did you appeal it? Because we are talking state law, and if the state administrative board make a determination, your appeal is then say, we disagree with this being a taken, or disagree with being a nuisance. And you didn't do that. So then it seems rather conclusive under Maryland law, this is a nuisance. Even when it comes to federal court. Comes to federal court, the question here is a federal takings claim, for which the question is, do you even have such a claim if it's a nuisance?
Your Honor...
And I think you pretty much agreed that if this is a nuisance, you don't have a takings claim. Do you agree with that?
Your Honor, I do agree to this extent with that position. If this was a public nuisance, that a legitimate body followed the law and adjudicated this property as a public nuisance, if that were the case, and they followed the law, and they rendered this property a public nuisance under the Prince George County Code, which defines a public nuisance, if they did that, then I would agree, and we would not be here
I
today.
just think it's a stretch. I mean, we look at habeas cases, and Congress is really limited what we can do with a state court decision, but this is a state matter for which the appeal would be for Maryland as its own sovereign to determine, is this a nuisance? And yet, it's sort of a collateral attack you're now making to us on a state law and saying, well, that's not good. The board didn't do its job, or they failed to do it right, but you didn't appeal that aspect of it. And if you had, and they said, no, it's not right, then I see, maybe the takings follows, but I'm having some difficulty understanding what is our role here as the federal court with regard to a state law determined by a state administrative agency that you did not appeal to any of the courts there for them to determine as to whether it was satisfactory under Maryland law. But you want us now to tell Maryland that its law is not, that the way it did this was not satisfactory, and yet they didn't get a chance to do it.
And Your Honor, I completely understand. I want to just note, it's not the General Assembly, it's not a state statute. It's Prince George County local ordinance. Prince George County admitted in this
How
case.
does that change anything? Because you know what that means. That means they can't operate except under the authority of the legislature. So if it is a Prince George ordinance, that doesn't give us jurisdiction over Prince George any more than Maryland. I mean, I don't know how that changes it.
It does, Your Honor, when a state actor violates someone's federal constitutional rights.
Did you raise the constitutional question in the state proceeding?
There was no state proceeding, Your
Well,
Honor.
there were 2 hearings.
I'm sorry. Okay, so let's.
We've already talked about that. Did you claim that they were violating the Fifth Amendment?
So, Your Honor,
The answer is no.
the answer is no, and the nuisance abatement board does not have
You
a.
first raised the Constitution in the district court.
Yes, Your Honor. The nuisance abatement board does not have the authority to adjudicate constitutional issues. The Circuit Court of Maryland does have that authority.
Well,
So,
you had an opportunity to go there and raise the Fifth Amendment.
Your Honor, if we did, it would have been removed to this court.
But you're talking about a takings clause. You want to be paid for your property, and you sold it. You sold your property, and you don't tell us what you sold it for. You may have sold it for 10 times what it was worth. We don't know. You may have sold it for next to nothing. We don't know.
Your Honor.
But we know you sold it because that's in the record.
Yes, Your Honor.
It was sold.
Your Honor, the other piece to that is that there were more than 20 years of license contracts with insurance industries that were eviscerated because of this. There were more than 11 employees' lives who were turned upside down because
What
of this.
does that have anything to do with the value of the property?
Well, Your Honor, it's the value of the real property, but there was property there was property here in the terms of the actual business license that my client owned.
So you're arguing a takings of the business license?
Your Honor, we're
'Cause
arguing.
I didn't see that.
And in the appellant's brief, we argue that all of the property associated with padlocking this business for 8 months, prohibiting the business from operating, and then.
The question that Judge Thacker is really getting to is a business interest is not a property interest. You're bringing a Fifth Amendment, you're bringing a takings clause, federal takings clause action. That's not a business interest, it's a property interest. And you're addressing business interests.
And Your Honor, I'm not, and I want to be clear, I'm not talking about the interest for one to pursue their profession. I'm talking about
11 employees, you talked about insurances and all other things. That's not a property interest.
the insurance contracts, Your Honor, the contracts themselves that were in place are property under state law. The insurance contracts, the goods and all of the equipment that my client lost as a result of this, the ultimate issue here, Your Honors, is that this nuisance abatement board is comprised of 7 members, none of which are attorneys, 3 of which are appointed from the agencies, the 3 agencies that actually are the only ones that file nuisance petitions. They're required to do certain things under the code, like submit a sworn statement to support a nuisance petition. They're required to give the respondent evidence before hearing, and the record shows that they didn't do any of this. Not only that, the worst part...
I think at the end of the day, your client does have a very compelling factual situation, at least when you look at it in the light most favorable to him. I mean, he's got a business in what is characterized as a bad part of town, so to speak. And that business is, he doesn't have control of everything that comes up there. People are parking cars, doing all kinds of things. But to go back to the basis of it, of whether it's a nuisance, comes under state law. And it seems to me that if a state makes a determination, be it through Prince George County or however, that it's a nuisance, that you then appeal that within the state system. And that's the difficulty. It's not just a jurisdictional question. I mean, you don't fold in that kind of action into a federal action by simply saying, well, it's a federal takings, because you are limited there to what is a property interest. And when you look at the case I gave you and the other cases on it, and it's pretty factually similar to what we're dealing with here, as to, because the same kind of argument was being made, is that this nuisance was really a property type taking, because they hadn't done it right, so to speak.
And Your Honor, my time is out. May I briefly respond?
Please.
Your Honor, if this was a circuit court case, if this originated in the circuit court for a nuisance action that a circuit court judge presided over, right, and issued an order that's a quasi-injunction, shutting down a business for 12 months, it would have been different if it was just a fine here. If it was a fine or if it was a temporary closure order. This was not temporary. The nuisance abatement board this administrative body shut down this property.
So what court would you appeal in Maryland? Do you appeal a board's determination like this? Where would it be appealed to?
It would be appealed to the circuit court, but that's the problem.
Circuit Court of Prince George's County.
Yes, Your Honor.
And then you could go from there to the High Court.
So, yes, Your Honor, you would go from there to the Maryland Appellate Court, but in appealing this to the circuit court, there would have...
And you didn't avail yourself of those opportunities. You went directly to the federal court and say, this is Fifth Amendment, without ever raising it in the state court, ever mentioning it. And you sold the property, and you didn't tell anybody what you sold it for. So how do we know, how could you even show that you lost anything? You may have made money on it. You sold it.
And Your Honors, the problem was the sale happened towards the end of discovery. It happened at the very end of this case. So that's the big problem. And Your Honor, the plaintiffs tried to comply completely with everything.
You said it was toward the end of discovery. Was it after discovery?
It was right at the end of discovery, Your Honor. That's why it came out. It was within weeks of the discovery deadline ending.
Well, you say
The discovery deadline had not ended.
The discovery deadline had not ended. And
So you could have put it into evidence, but you didn't, and now we have no idea, as Judge King says, what the value of the property was.
we have what the property was sold for, Your Honor. What we don't have is the appraised value of the property at the time. We don't have that, Your Honor. I will just note that the plaintiffs tried every effort to comply, even with the nuisance abatement board order, and that's the issue with the regulatory taking here. The plaintiff even submitted a request at the behest of the inspector who came to the property and told him to send an email to the nuisance abatement board asking them to lift the order because he had complied with the nuisance abatement board's order for abating the nuisance. That was done. It was ignored. And the nuisance abatement board member said...
We've been very generous
I'm sorry.
with you on giving you time. So,
I'll-
you've saved some time for rebuttal.
Yes, Your Honors.
Why don't we let Mr. Murray make his arguments?
Thank you, Your Honors.
Yes, thank you.
Good morning. May it please the court, my name is Andrew Murray on behalf of Prince George's County, Maryland. Your Honors, this case is sort of digressed into the form of an amoeba with no shape or rhyme or rhythm to it. So let me try to wrap the arms around what really is the sole issue raised in this case, page 1 of Mr. Wood's brief, and that is whether the district court erred in applying the 3 Penn Central factors to his Fifth Amendment takings case. And of course, Penn Central applies to ad hoc regulatory takings, not per se takings, not physical takings. The court below noted that the plaintiff did not raise a physical takings claim, yet he makes arguments before this court of a physical taking. He makes arguments of a per se taking, not raised in his statement of issues. So his tack before, in this case, was create a public nuisance, flout local officials' efforts to get compliance with abatement, and when finally called to task to be held accountable before a nuisance abatement board, challenge the process and launch counter accusations. The district court didn't buy that tact.
Well, he says the nuisance wasn't his property at all, and that the photographs are not of his property. What's your response to that?
Thank you, Your Honor. My response is that what is not at issue in this case, as Judge Wynn has noted and as Judge King have noted, is whether or not a nuisance occurred. That plane flew in another direction and is not before this court. What is also not before this court is the constitutionality of Section 14173 of the County Code, whether the authority of the Nuisance Abatement Board to abate a nuisance exists, and as I said, whether a nuisance...
So it doesn't matter whether or not that was his property? He says it wasn't his property, that where the nuisance was found was not his nuisance.
Well, the Nuisance Abatement Board found ample evidence of nuisance
That it was.
On his property. Yes, Your Honor. And, you know, clearly he testified that some of the dumping, for lack of a better term, this is his property adjacent to a residential area was essentially a dump.
He could have appealed that in the state court system.
He did not appeal that,
And he didn't.
and per the county code, he had a right to appeal from the Nuisance Abatement Board to the circuit court and then on to the 2 appellate levels of the Maryland court system, which he did not do, had he wished to contest whether or not a nuisance was actually occurred.
Right, and then I also want to give you the opportunity to respond. Opposing counsel said appellee admitted to engaging in some sort of fraudulently signing something. Do you know what he's talking about?
I don't.
Okay.
I don't,
Hard to
Your Honor.
respond
And in the case below, he made a claim about disparate treatment with racial undertones, and the court disposed of that. And I think this statement here about fraud and these irregularities is sort of a workaround the fact that issue is not before this court. It's just the sole takings claim. And so it's clear that there was no per se taking, and we're here on the Penn Central.
And so all his arguments about how his property was locked and he couldn't get on it, that was not what was at issue below. Does that matter?
Well, the district court addressed that, Your Honor. The district court
Right.
addressed the padlocking and noted that Mr. Woods was given some access to his property. That was clearly in the record. And in fact, when the NAB, the Nuisance Abatement Board, issued its first order in May of 2023, in your joint appendix, you will see that on December 7th, his counsel emailed the DPI, Department of Permitting, Inspections, and Enforcement, the agency responsible with enforcing these provisions, requesting a reinspection because the property had been abated. So sometime between May and December, the property, according to plaintiff, all the problems had been abated, and then we know that shortly thereafter he sold the property. So, and as we know, there is no evidence in the record about what the sale of that property was, but it's pretty clear that a piece of property that has been cleared of rubbish and debris that the county was on the property owner about would be worth more than the sale of a property that was loaded with the garbage.
And by that timeline, it also appears that he was able to access the property sufficiently to abate the nuisance.
Which it seems pretty obvious, Your Honor, of course. And so, without belaboring, without going through each of the Penn Central factors, I just want to address the one that the court found in favor of Appellant Woods, and that was on the second factor, investment-backed expectations. And the court below cited irregularities in the board's process. And for the proposition that an investor in Mr. Wood's position would not have foreseen nuisance abatement board irregularities, it looked to the Willowbrook case, which I believe was decided by this court, that had to do with rent control and I believe in Baltimore City, and a hold on any fines for late rent, and in that case, essentially the landlords, while the district court noted that the landlords could expect some regulation, it was the breadth of that regulation that the landlords could not have anticipated, and so the district court similarly found that Mr. Woods could not have expected irregularities in the nuisance abatement board process. But in Willowbrook, the breadth of the regulation enacted by Baltimore City essentially exposed the landlords to additional harm by not being able to increase rents, by not being able to levy fines. In this instance, and I suppose I take issue with the district court's conclusion under this element. In this instance, the irregularities cited by the board did not expose Mr. Wood to any additional harm. In other words, had everything been followed as per the county code, there's no question that a nuisance would still have been declared. There's no question that he would not have been able to make a takings case because of this declaration of a nuisance, because the evidence was so clear. And so what I'm trying to say in sort of a long way is I think that the district court could have found for the county on that element of the Penn Central analysis as well.
Are you familiar with the case that I mentioned earlier?
I am not, Your Honor.
It seems to me you ought to take a look at that case.
I agree.
I mean, this case came down last year, and it seems to really address the whole question of property and takings. And there's a factually analogous situation here, an inverse condemnation type proceeding. This was, but it's basically the same kind of case in which it was alleged that damages should be paid under the takings type clause. And the court made it very clear that, a nuisance abatement, if something is a nuisance, you're not actually taking it. So the property is not been taken. I think, well, anyway, you didn't cite it, so I'll leave it alone.
So, Your Honor, I think the crux of this case is really the county's putting a lock on the gates to the property, which this is really what I think brings us here. And the district court analyzed that and found that access, limiting access, and citing the Blackburn case and others, limiting access is easily distinguished from actually physically occupying or acquiring property for the county or for the benefit of a third party. I'm reminded when my kids were young and I asked them to clean their room, it was always met with some equivocation, hesitation, but when I took their cell phones away, the room seemed to get clean really quickly. The nuisance abatement board order would not be worth the paper it's written on unless there was some real enforcement mechanism to get the property owner, especially in this case, Mr. Woods, who, if you look at the second nuisance
What
abatement
is the
board.
simplest way you think this case should be disposed of? I mean, much has been said here, but it seems very clear if you deal with just the property interest, much of what's being said is not necessary.
Agreed, Your Honor. There's no.
So what is the simplest way?
It is. And there's no evidence of a diminution in property. The property was sold likely for more than it was worth, you know, at the time that it had all the rubbish on it. This catch-22 that appellant cites goes both ways. He claims he didn't have access to the property, but by the same token, the county can't enforce its orders.
So this came out before discovery was completed, the sale of the property?
Apparently so, yes. And so, and that could have been put on the record and was not.
You referred to the nuisance abatement order. Is that the first order or the second order, or the two of them read together?
Well, there were two hearings, Your Honor. The second.
There were two hearings.
Right.
And that the plaintiff had before whatever the commission's called there, and there were two orders entered. Are those orders to be read together as one nuisance abatement order, or is the first one or the second one the nuisance abatement order that you referred to?
I would say it's the second order would then supersede the first, Your Honor, so.
Or amended the first, or followed?
Yes.
Whether it was 8 months apart, 6 months apart?
Yeah, May and September.
Okay,
May, the first one, September, the second
3
one.
or 4 months apart.
Yes. So, Your Honor, I would ask you to respectfully to affirm the decision of the district court, and unless there's any further
But
questions.
just one last question. The county did put the padlock on the property. And I take it that's an authority to abate a nuisance?
Yes, Your Honor.
Where is it indicated that that's part of the authority of the county to do that?
I don't know that we would see that in the county code, Your Honor, but the general exercise of police powers to enforce and abate the nuisance, there has to be some enforcement mechanism. Otherwise, as I said, you know, the order is not worth anything, and in fact appears to have been flouted, because in that second opinion of the nuisance abatement board.
But how can he abate it if it's locked?
Well, he apparently did abate per his,
Right.
per his email, but it required coordination with county employees to come and unlock and open the gate so he could.
And he complained at the second hearing that y'all hadn't let him on the property after the first hearing. You kept him off. That's the reason he couldn't do whatever he wanted him to do. So, he made a complaint about that, and that hadn't been mentioned here before.
Yeah, he did complain about that, Your Honor. There was evidence also in the record
Locked
that.
out.
There was also contrary evidence that he was allowed access to the property. And in fact, by December, his counsel.
But in the second order, the board tried to remedy that, or follow up on it or something.
Yes,
And provide that he could get proper access or whatever he wanted, and to get the job done.
correct, Your Honor. And the board, I believe the language the board used in its order was to have Mr. Woods contact DPI more than a few hours in advance or a day in advance.
DPI was that, DPIE, whatever that was, those are capital letters, abbreviation, acronym for
Yes.
whatever was
Yes, sir.
supposed to be letting him on the place.
Yes, sir. Department of Permitting, Inspections,
DPI.
and
I
Enforcement.
hadn't heard that before.
Department of Permitting, Inspections, and
Maybe
Enforcement.
it's a part, sounds like it ought to be in the federal government.
Yeah. So, the county exercising its police powers to abate a nuisance does not require compensation under the Fifth Amendment. I respectfully request the panel to affirm the decision of the district court. Thank you.
Thank you, Mr. Murray. Mr. Hallett?
Thank you, Your Honors. Your Honors, Justice Thacker, I'll point you to the joint appendix that references the fraud allegations I mentioned on the record. That's JA 191 at Statement of Material Fact 5 and JA 198 at Statement of Material Fact 37. those reference deposition testimony from nuisance abatement board members, wherein they noted that when a nuisance petition was filed by one of the three agencies and it was given to the administrator for them to vote on, a vote never happened, and in one of the two online check boxes that they're supposed to mark, they check that they receive a sworn affidavit, and they admit on the record that they never had received an affidavit for any of the nuisance petitions that were submitted to them. And
The
since
rules
this,
required affidavits,
so the Prince George,
and they submitted some evidence that wasn't affidavits.
so the Prince George County
And they
Code,
used the word sworn affidavits. What's the difference between a sworn affidavit and an affidavit?
they didn't submit any affidavit. My point is, what the code requires, Your Honor, is the standard form, which is a nuisance petition form, a sworn affidavit. I mean, we would have even taken affidavit, whether it's.
Well, an affidavit is an affidavit. It doesn't, you don't have to use the word sworn in front of it.
The code does, Your Honor, so
But,
the code does. I agree with you
yeah,
completely.
but that's for them to be arguing about, not us.
Well, Your Honor, that goes to the regulatory taking aspect, right? That goes to one of the three Penn Central factors. And so, Your Honor, my point is that the character of the regulation here, there was a clear requirement for the nuisance abatement board made up of non-attorneys, right? Three of which sat from the agencies that actually filed the petitions. There was a clear requirement for how this board was supposed to work, because it was not a court. It is not a court, right? Even though it's entering closure orders for up to 12 months that are quasi-injunction in nature. It's not a court.
It's an administrative body.
It's an administrative body at the local level.
I thought I was gonna, I'm sorry, Judge King,
No,
go
I'm
ahead.
sorry, you go.
I thought you were gonna point me to somewhere where they admitted fraud. These are your, well, these are appellant's statements, and I don't see the word fraud or fraudulently in either of those two paragraphs. Now, you do say egregious misrepresentations, but where's something in quotes where they admitted we fraudulently signed something or did something? Because that's what I thought you represented in your opening there.
And Your Honor, I apologize. Let me be clear
You were
about.
stretching a little bit there,
So,
lot.
weren't you?
so
That's the kind of thing we don't think much of in these courtrooms.
No, Your Honor, and I apologize, I just want to be clear. We argue that it's fraud in the brief because during the depositions, they
Yeah,
clearly.
but that's not what you said when you stood up here at the podium and said that they admitted that they fraudulently signed something or fraudulently did something. That's what you said. Was my recollection. But that's not an accurate recitation of what happened, is it?
Your Honor, let me be clear of what happened and what's.
So no, so that wasn't accurate. What you said earlier was not accurate.
So it was, Your Honor, but I want to caveat it. It was. And the deposition transcripts that are in the
It was
record.
accurate?
Yes, because this is what.
They admitted fraud.
So they admitted to engaging in fraud, yes.
And you said you said that's what they were asked, and in their deposition testimonies, that was the colloquy before. And so is there somewhere in here, is there a deposition testimony I can look at? Where they said that? I thought that might be what you would point me to, something that actually supported your argument.
Your Honor, those statement of material facts actually reference the.
I see that there are references, so you want me to go find all of the rest of that somewhere in the JA?
Oh, no, sorry, Your Honor.
No, I don't want to do this anymore. I understand what's
Okay.
going on.
Yeah,
But I sort of took your fraudulent allegation to be there's an affidavit that the county code requires. There was no affidavit. And then the code requires that the board checks boxes regarding the hearing. They didn't do that. And that flowing from that, I guess there's an inference you were saying of there being a fraud, that they're doing something that is not in compliance with the code. No affidavit was attached to it, as the code requires, nor did they check those boxes. And that's pretty much there. In other words, I think that's a given, to the extent it has any relevance here.
Yes, Your Honor, let me add one thing to that. One of those check boxes specifically said, I have reviewed the affidavit that's required under the county code. And they all checked the boxes, and they all admitted on the record that they never reviewed any affidavits in connection with a nuisance petition. And yet they checked these boxes that said that they had reviewed these affidavits that were required under the county code. And I apologize, Your Honor, that's what I was talking about. Your Honors, I just want to clarify two things really quickly in the last 30 seconds that I have. The Supreme Court in Cedar Point made clear that a taking of property, however long, if it's deemed a taking, it doesn't matter if it's 1 month, 5 months, permanent, a physical taking of property is a homeowner or a property owner is required to just compensation under the Fifth Amendment. The temporal nature of the taking is irrelevant under Cedar Point.
Can it be a partial taking, or must it be a complete taking?
It doesn't have to be a complete, the physical taking has to be, you have to bar someone from being able to access their property and being able to use their property. The regulatory taking analysis under the Penn Central factors can be a partial taking, and then there are those 3 factors that you look at. And I'll just note that the court found 1 factor in our favor. The Supreme Court has never, I'm sorry, Your Honors, I'm out of time. Can I just finish this brief point, if that's okay?
Be quick about it.
Thank you, Your Honor. The lower court found 1 of the factors in our favor. The Supreme Court has said these factors are not dispositive. And so therefore, just finding 1 factor in our favor should have sent this case to a jury to weigh the evidence and determine and do the balancing test if the Penn Central regulatory taking analysis applied. We are saying the physical taking analysis applied, so you didn't have to get there. But since the lower court did analyze it under the Penn Central and found 1 in our favor, because no factor is dispositive, we're arguing that this case should have been sent to the jury then to weigh the factors and weigh the evidence and credibility to make a determination on whether a taking has occurred. Thank you, Your Honors. I respectfully request that the court reverse and remand this case to the lower court.
Thank you very much. We'll come down and greet counsel and then go to the next case. That's all right with my partner.
That would be,
An unmistakable agreement to
the
delegate?
question in this case arises because this is a third party.
That's correct.
And the third party generally, particularly, I know clearly that it was an incidental third party, is just not a party to the contract. And the question is, I think the controlling law, it seems to me, that you all agree is, I guess, is Delaware law, not Delaware law.
Is Delaware, yes, Your Honor.
Delaware law on this. And so if you're saying the judge here made an error, you are saying he erred in terms of how he applied Delaware law to this. Is that correct?
That is one error, but that is not the primary error that we're focusing on. One, we don't believe that we're incidental. We believe that we're intended, and we believe it was error for the court to find that we were not an intended third-party beneficiary.
So
But
that we are
before-
clear in terms of the factual thing here, because I found this to be rather intriguing. And when you think about how you sign these contracts, this is a contract in which seems like NextGen is like a clearinghouse type agency, sort of
Fair.
get people to, submit
It's a lead generator.
bids. And then part of it is this agreement that when you access it, you say, okay, you consent to certain things, and one of it is to arbitrate claims that come out of it. And I'm thinking, and I'm maybe getting ahead of it, but let's delve into the issue here. The whole question of beneficiary materiality, the whole bit that's there. But even with that, maybe for the contract, but I'm wondering if you just look at the provision to arbitrate, was that an intended benefit for the third party, or was NetGen more interested in how things would come against it? You see where I'm going with that?
I do, Your Honor.
It's a difference of whether you look at this holistically, which it seems to me, it does kind of favor your position when you look at it holistically. But if you look specifically at the arbitration clause itself, it says, why is that in there? It's a procedural way in which you go, and was there any benefit to say, I want this, and then for everybody else that comes along who's not a part of this, they get this benefit, when I could very well see NetGen in that instance is protecting its interests.
Sure, so a lot to unpack there. First,
Well, it's pretty simple. It's pretty straight up. Pretty straight up. I want to make sure I don't want to unpack a whole lot of stuff here. So that's why I say I want you to answer that question,
Yep.
because I think it's dealing with the arbitration clause. I mean, when you start unpacking, you're gonna get me into this argument, the whole thing, which I'm telling you, I think is pretty good. But when you deal with that arbitration clause, it becomes less clearer to me that's the benefit.
But Delaware law does not allow us to ignore the entire relationship and all of the facts and circumstances, which include all of the things that perhaps are more favorable to us, right? We certainly agree with the notion that we are an intended beneficiary of the entire relationship that was created by Ms. Sessoms going online, filling out this form, consenting to be contacted by our client, a group of marketing partners, including our client, to receive the quotes that she was asking for. As to the arbitration agreement itself, however, what we have to look at is, one, the agreement, which is very broadly worded. It is not limited to claims only between NextGen and Ms. Sessoms, and it requires her to arbitrate, including the arbitrability question, which I hope to get back to, her use of the website, claims arising from her use of the website, claims arising from the consents that she provided, claims arising relating to the information, products, or services of third parties. This relationship between Sessoms and U.S. Health Advisors does not exist without U.S. Health Advisors. It only exists if the marketing partners are here. As you said, Judge Wynn, you looked at this like a clearinghouse. NextGen makes money how? It sells TCPA compliant leads subject to binding arbitration to third parties like my client. What did Ms. Sessoms want when she went online? Ms. Sessoms wanted to receive insurance quotes. She went on the website 7 times.
And I know this is the merits, but you just said she wanted to receive insurance quotes, and she got insurance quotes, and now she's complaining about it.
That's correct.
I mean, that's
Resulting
what she
from-
wanted.
Exactly. I agree that the merits are silly here. She consented. She does not dispute that. She has not disputed that at all throughout these proceedings. I believe in the court's order, the district court's order, there was a finding that she had agreed to arbitrate. She does not contest the arbitration agreement. She doesn't contest that the delegation by incorporation of the AAA rules is clear and unmistakable evidence of delegation. The arbitration agreement is written extremely broadly, specifically referenced third parties, relates to the use of the websites, relates to the consent that she provided. And this claim arises from her opting in on that website and agreeing to the terms and conditions, which my friends do not dispute include this valid arbitration agreement. I do want to get back to the delegation issue, however, because before the court can get to a third-party beneficiary, our district court had to conclude that in the face of this clear and unmistakable delegation provision, he was permitted to resolve the question of arbitrability. We say he was not. We say that this court's
Do you
decisions,
think the arbitrator should be able to resolve whether something belongs in arbitration?
that's correct, Your Honor. This is
Where
a
in the
question of
FAA
enforcement.
Where does the Federal Arbitration Act say that?
So Section 2, Section 3, Section 4 all discuss generally an agreement to arbitrate.
And
And
it
we,
just makes sense for the district court to determine, does this belong here or there? And why does it matter to you? You're not saying you need that point to win this case, do you?
I don't need that point to win this case if we win on the third-party beneficiary,
Not
but what,
even as strong as the other points. I mean,
Well-
it seems like you can spend some time talking about that, but I don't know where you're going with that one. I mean, the Federal Arbitration Act pretty much tells you right up from the beginning, to make a determination of where you belong is really a federal district court issue. And then, once it's said arbitration, then it goes into all the rest of the issues there. But the initial, it just doesn't make sense to me that the arbitrator would get to determine whether this belonged here or there, because if he said it doesn't belong here, what's he gonna do with it?
so you'd be correct, Your Honor, if this were just an arbitration agreement without a delegation clause. What the law says, what the Supreme Court has said, Arthur Anderson, Rennes Center, Henry Schein a few years back, what the Supreme Court has said repeatedly is that, one, non-signatories can enforce an arbitration agreement under the FAA.
Don't you also have to get beyond our opinion in Rogers?
Well,
Doesn't-
it's not every day I get to stand before a panel and say, hey, I think you got it wrong in Rogers, right? In a case before
And
the
you think
Fourth
that a
Circuit.
panel, even if we got it wrong, you think a panel of this court can overturn precedent?
I don't know why a panel of this court cannot find
That's a
that.
swim you don't wanna take.
Well-
You might wanna, I'm telling you, not gonna go anywhere with that one.
It's not the easiest position to be in, but
It's
we
not-
believe,
It's an impossible position. We're not gonna overrule another panel.
Judge King was on the panel, so I
It
understand. but-
doesn't matter. It could have been another panel altogether. We're not gonna overrule a panel of this court. It's not gonna happen.
That's fine. Then, we
So
believe.
you have to distinguish it somehow, can you?
I can distinguish it, but first, let me just get out that we believe that the FAA and the Supreme Court preclude a finding like what the district court made, that there is a categorical prohibition on non-signatories enforcing delegation provisions. That's one. Moving past that, if we look at Rogers, Rogers has to be construed and interpreted based upon the underlying arbitration agreement that was at issue in that case. In that case, it was clear and unambiguous that the dispute to be arbitrated was only between those parties. And what the court said,
It looks a lot like the arbitration agreement here.
it looks nothing like the arbitration, with all due
Well,
respect.
I'm reading it, and go ahead. What parts are not like
Well,
it?
this sounds a lot like it. If you look at the language, it says, it is a court, not an arbitrator, that must initially decide whether a non-party to an arbitration agreement is in.
Very next sentence to that, but if there is a valid delegation provision, then the court is powerless to resolve the arbitrability question. Just as in AT&T Technologies 40 years ago, the court said if the issue is arbitrated, the court cannot resolve the merits of it. It has to let the arbitrator resolve that. Henry Schein says, just like the principles espoused in AT&T Technologies, if the parties
So you're
to the
going back to
contract-
saying Rogers is wrong?
Well, I was just responding to Judge Wynn's question, but
You're going exactly
But
there.
if the
I just don't know why
question-
you're spending time on this issue.
if the question of arbitrability has been delegated, then the court is powerless to resolve it. But in Tug Hill, what's important, when the this is from Tug Hill, when the delegation provision is read in the context of the arbitration clause as a whole, it is plain that Rogers agreed to arbitrate issues, including threshold issues, arising, and it's emphasized, between him and Riga. That's the third part, the original party to the
What
agreement.
again is the threshold
But-
issue, in your opinion? The threshold issue is what?
Arbitrability, whether or not a non-signatory can enforce the agreement has been delegated to the
Whether
arbitrator.
this non-party can even come in and enforce not just the arbitration clause, but the contract.
No, the delegation provision, which is in the arbitration agreement. So the delegation provision is a separate agreement recognized under the FAA and the Supreme Court precedent as having the same rights, equal footing to the larger arbitration agreement within which the delegation provision lies. So there's two agreements here in this arbitration agreement. There's, hey, we're going to resolve the merits to arbitrate, but we're also going to delegate the question of arbitrability to allow the arbitrator to resolve scope, validity, enforcement. This is an enforcement question.
Who is we?
The parties to the underlying agreement for
The
which
third
we are
party-
seeking rights.
The third party that's in this case
Sure,
is part of this agreement.
we are a third-party beneficiary to the agreement.
And
I'm
you
not
are
taking
part
any
of-
other
but
position.
You say that, but that is a question that has to be addressed under Delaware law. Are you a beneficiary under the agreement? You jumped there, and I agree you could jump there, but that's a step beyond where you first have to get, is you gotta determine whether, first of all, the Delaware law permits that as a beneficiary. Then there's a question of materiality and the whole that comes up too. And so to jump down the road on this, it says we are, and therefore we have to enforce it, those things have to be made as an initial matter. I think the Federal
That's not our
Arbitration
position.
Act intended for these initial questions to go to federal district court, delegation clause notwithstanding. But tell me a case that holds exactly what you've just been saying.
Henry Schein says that, and when you look at Arthur Anderson, it says it was the same issue raised by a party saying that a non-signatory cannot enforce an arbitration agreement. It did not involve delegation. What Justice Scalia said in Arthur Anderson was non-signatories do have rights under Section 3 to seek before this court a stay. Non-signatories can enforce a valid agreement to arbitrate under the FAA.
I'm going to absorb where you're going with this, but I think that the differences we're making, at least I have on this, is what is the threshold issue? And the issue here, in my opinion, is whether a third party can even enforce the rights of a contract. That's not about arbitrability. It's about a third party standing to do contract.
The arbiter,
So it's sort of like you jump down the road on it, but in the general world out here, when you have a contract and then you have a third party, the general rule is third party can't enforce it. I mean, so you have, but under Delaware law, there are ways in which you can get there. That's the beneficiary, the interest, the whole materiality part of it.
the arbitrability question asks who decides that. And where the agreement contains a delegation clause, the answer is that the arbitrator decides the third-party beneficiary issue. We are not arguing that we just win on it. We're saying the question, because of the delegation
We don't know in
provision,
the first instance whether this party can even enforce this arbitration.
it's for the arbitrator to decide. That's what a
Something he
delegation
has not
provision
even-
is.
He can't even enforce it. So you can
Sure
go
he
to
can.
arbitration without there being a question of can he enforce this contract?
That is the question that the arbitrator gets to answer because of the delegation clause. So back to Tug Hill. Oh, I see my time's up. I have 5 minutes for rebuttal. Thank you.
Thank you very much. Mr. Phillips?
I made a mess, Jacob. Give me 1 second. Sorry.
Thank you, Your Honor. Jacob Phillips, may it please the court. To Judge Wynn's point, their entire argument is an exercise in question begging. The issue before the court is whether defendant has standing to enforce contractual rights, to delegate the question of arbitrability to an arbitrator. Defendant's position is that the arbitrator decides that very question. In other words, they're assuming the point that they're trying to make. This court in Rogers specifically said, and I had the quote that Judge Wynn already gave, which is that it is a court, not an arbitrator, that must initially decide whether a non-party to an arbitration agreement can enforce
So
arbitration.
that's the threshold issue in the case is, can the court decide it? But once you say, okay, court can decide it, it seems to me that does not end this case. Then you determine, the next issues as follows, an error in denying this motion to arbitrate. The initial question, which your opponent spent a lot of time on, and maybe well spent, I'll go and restudy it, in terms of where he went with that on that, this delegation business. So, but that's not the end of the inquiry. I mean, once you say, okay, judge, you can, in district court, decide whether or not this is an arbitration question or not, then the question is, was it error to deny the motion to arbitrate, or, concluding there's a trial, as you say?
That's correct, Your Honor. The district court correctly decided that it was the one who had to decide whether the claim was subject to arbitration, and then it correctly decided that this claim is not subject to arbitration. The reason is the text of the contract itself. The text of the contract itself says that this agreement provides that all disputes between you, meaning plaintiff, and us, meaning NextGen, will be resolved by binding arbitration. It does not say that any claim between you and third parties will be decided by binding arbitration. Then the text of the arbitration clause itself refers to you and we, meaning plaintiff and NextGen, nothing about third parties. And the reference to products or services of third parties refers to NextGen's liability relating to products or services of third parties. In other words, it references products or services of third parties, but it's referring to claims that NextGen is liable for the products and services of third parties. And so if plaintiff was suing NextGen and saying, hey, you're vicariously liable for something your marketing partner did, then NextGen would be able to compel that claim to arbitration. What it does not say is that the third parties themselves have standing to enforce an arbitration clause that is between NextGen and plaintiff. And the district court correctly found that based on that there was, at the very least, there was no material benefit intended for defendant to be able to invoke the arbitration clause that exists between NextGen and plaintiff. And so we would say that
Address that part of the clause, that part of the clause does address the third parties and the consents that have been provided with information of products of third parties. How does that impact here? It says all claims related.
all claims against NextGen. So what it says is you and we agree that all claims, disputes, and controversies which you may contend NextGen or its affiliates, members, officers, or directors is liable relating to the information, products, or services of third parties. So it's still referring, it talks about third parties, but it's referring to NextGen's liability relating to the products and services of third parties, which is what I was referencing before, and saying that if plaintiff had brought a claim against NextGen and said, NextGen, you're liable for defendant's products or services, then NextGen could properly invoke the arbitration clause. But that does not mean that the third parties themselves can invoke an arbitration clause. The contract is between NextGen and plaintiff. The contract is not between plaintiff and defendant. So a way of thinking about it, the Fifth Circuit actually said this in one of their cases, a way of thinking about it is, could defendant sue plaintiff or NextGen for breaching this contract? One of the other, not the arbitration clause maybe itself, but any other part of the contract. Could defendant come in and say, hey, you didn't do what you told plaintiff you were gonna do, NextGen, we're gonna sue you because we have third-party beneficiaries standing under this contract? Of course not, of course they couldn't, because they don't have contractual rights under this contract as a third-party beneficiary. And because they have no standing to sue for breach of contract, they also have no standing to invoke an arbitration clause. Delaware law is properly cynical about parties coming in and saying, hey, we have no obligations under a contract, but we want to enforce it anyway. Delaware law says, well, maybe, but you gotta give us strict proof that you were an intended beneficiary of this contract, and nothing in the terms of services indicate that they are. The fact that they incidentally benefit from it, the fact that they're going to be provided the data that plaintiff gave to NextGen so that they could try to solicit quotes or whatever, has no bearing under Delaware law, because you have to prove that it was a material part of the contract. And it's their burden under the standard of proof to do so. The district court correctly found that they failed to meet their burden. Unless the court has specific questions, the only other point that I would make is that they say at the very least this should be set back down for a trial on the question. I would merely point out that A, they didn't ask for a trial by jury. They sort of relied on the district court to be the fact finder. The district court was provided the affidavit that they rely on. The district court didn't say, I don't believe you, I don't find you credible, CEO. What the district court did is he looked at the affidavit and said, based on the evidence that he was provided, that they didn't meet their burden of proving by a preponderance of evidence under the summary judgment-like standard that applies here. And so we would say that there is no reason to send it back down for a trial. I have a lot of remaining time, but I'm happy to give it back to the court unless the court has specific questions. Thank you, Your Honor. We would just ask that the order on appeal be affirmed.
Thank you. Mr. Backman?
Yes, Your Honor. Can I have all his extra time? Never hurts to ask, I guess. Just real quick, Judge Thacker, so we were talking about the arbitration agreement in Rogers as compared to ours. A couple of things to point out from Rogers. There was language in the agreement that expressly says Rig-Up will not be a party to disputes or negotiations of disputes between you and the companies. And then the arbitration agreement itself specifically says, in the interest of resolving disputes between you and Rig-Up. Our agreement does not contain any limiting language to only disputes that arise between Ms. Sessoms and NextGen. And importantly, to the holding.
Except for where it says you and we agree.
Yeah, sure.
Are
So
you or are you we? Or
So-
are you neither?
we are neither.
Right.
And I don't take a different position, but it doesn't say you and we agree that disputes between us or only between us. It's simply saying we are the parties to this written document. You agree to all of these things, and we agree to all of these things. And so if the consent is one of those disputes of which claims arise and will be subject to arbitration, you agree to that. If it's the use of the website, you agree to that. If it's the information, products, or services of third parties, you agree to that. And I was reading from Tug Hill before in terms of the
Where
court's.
do you see that? If it's the information, products, or services of third parties, you agree to arbitrate with the third parties,
Yes, Your Honor. So.
as opposed to with we, you
Sure.
and we.
Sure. So I think the interpretation is you and we agree. So for purposes of Ms. Sessoms, we can take out the and we. You agree that all claims, disputes, or controversies arising out of or relating to your use of this website, to the services provided by NextGen, any consent you have provided to us, or to any acts or omissions for which you contend NextGen or its affiliates, members, officers, or directors is liable relating thereto, or to the information, products, or services of third parties, shall be finally and exclusively settled by binding arbitration. And we
Right,
can't,
as between you and we. You have to start at the beginning with the you and we.
but there's no between. So if,
Oh, okay, because it doesn't have the, your argument is because it doesn't have the word between in the same way that, whatever
Your
that
Honor.
other case was.
yes, I think that would
That's
narrow
your,
it, and that would
okay,
limit it.
I understand your argument.
Thank you, Your Honor. And in the Rogers case, the court, after discussing how that arbitration agreement is between him and Rig-Up, the court says, but he did not enter into any agreement that allows an arbitrator to decide whether a third party like Tug Hill has rights under the arbitration agreement. We submit to you that this arbitration agreement and all of the facts and circumstances demonstrate that this is more broad, that it is not limited. And even the court, the district court said, U.S. Health Advisors correctly argues that it was an intended third-party beneficiary of the agreement. So even the court acknowledges the broader scope here. And I think it's important, going back, Judge Wynn, to your question about third-party beneficiary, we are, at the very least, a material purpose to the agreement.
Well, that's kind of the big issue. When you look at what the district court did, I mean, I think the district court did say, or recognize that the third party was some type of a beneficiary. Well, Delaware law didn't set out. There are 3 different types of beneficiaries. Of course, incidental would be not one you could deal with, but certainly the donee of a beneficiary or a creditor could be. But the question, it seems like to me, the pivotal question is the question of whether there was an intent to benefit this third party, which is what you've gotten at. Here's what the district court replied and how it held on it. The district court said, Next Gen would have contracted with Sessions even if it could not include the benefit to USHA. That sounds like but for. And the question if it's a question here, I don't know if it's something we can resolve here, but I don't think that's supported under Delaware law, the but-for analysis, but I don't know if we resolve that here. How does that deal? How do we deal with that?
We do. You resolve it, you send it back to him and tell him he misapplied the law, because that is not the third element. I wrote the same thing down. This is a but-for causation standard that he created. The question is not whether or not these parties would have made a deal with or without the third party. The question under Delaware law.
We misconstrued the Delaware law?
That's correct, Your Honor. The question on the third
So
element.
you're asking us to send it back so he can apply the law
I think-
as it should be, not in a but-for?
I see my time's up, but I'd like to answer this question. I believe that this is a de novo review, and you could conclude that not only did he get the law wrong, but he misapplied the facts using the correct law. It is not whether it was the material purpose.
De novo would
It's whether it
allow
was
us to
a
make the
material.
legal determination of whether but-for is the law in the case, but in terms of the factual application of it to the proper standard is a district court function.
I contend that you can reverse it and you can make the conclusion that under this
You're
record.
exactly right. We can do that.
That's
and
right.
have done such a thing there, but that's not the way we normally operate. You're right. This court can do a lot of stuff, and no one's going to challenge it. But that's not the way
Well,
we
I
do
tried
it.
earlier,
because
but-
we don't want to take the district court's job away from him. First of all, we're not going to create that much. We start doing this in every case when we find that there's another standard, and we find ourselves conducting a mini trial up here. That's not going to happen. This is an appellate court. The district court is very capable of doing its own analysis of it. But my question on that is that a remand, if we were to rely on that basis there, that this is not but for, that it really is a different standard that he should apply it, and the court should apply that, could still come against you, I guess. I don't know if you use a different standard, but he has to do the right standard.
Agreed. Yes, Your Honor.
All right.
Agreed. I see my time's up. Thank you very much.
Thank
It was a
you.
pleasure.
We appreciate counsel arguments, and we'll come down and greet counsel as we do, and then we will take a brief break.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
You may be seated.
We're missing some law clerks.
We'll call the third case, number 256634, Marcus Ingram versus Israel Hamilton et al.
Mr. Carroll?
Yes, Your Honor, Seth Carroll, on behalf of Mr. Ingram. Let me just say what a privilege it is to be here arguing today, and always a pleasure to deal with the Attorney General's office, who allows you to dispute issues without becoming personally adversarial. This case is not about whether prisons may respond to contraband. It is not about whether visual strip searches can ever be used in prison. They can. And it is not about whether a search of some kind before a no-contact video visit might be reasonable. The question's narrower. It's whether appellees are entitled to summary judgment on a policy requiring repeated strip searches before and after no-contact visits. And in particular, when the determination regarding the justification factor under Bell and the rational relationship factor under Turner really turn on a dispute of fact, which is whether or not it is possible.
Why would we apply Turner at all? Isn't it clear that Bell is what's applicable here?
So this court and the United States Supreme Court have leaned on Turner in cases involving policy. Bell is a case that analyzes the reasonableness of a particular search, and Turner is helpful in determining the constitutionality of a particular prison policy. So they can be used together. There's no tension between applying both tests in a case like this, which involves a policy for strip searches rather than just...
But Bell addresses the factors to be considered in strip search scenarios, correct?
I think the justification factor in Bell relates to the strip searches themselves, yes, and the particular search aspect of that. But Turner is informative when a policy is involved because it really allows the court to analyze that.
Why are you pushing so hard for Turner? Do you not think you can win under Bell?
No, we can win under Bell, but I think Turner is applicable. This court referenced Turner in Johnson v. Robinette. The United States Supreme Court referenced Turner in Florence. Turner is referenced in these...
I think Turner hurts you.
How is that, Your Honor?
Well, I don't have to explain myself. I'm here to ask questions.
Well, one
I'm
reason,
not just observing.
I understand.
Turner says the warden runs the prison,
Yes, sir.
basically. And you're suing the warden.
Correct, Your Honor. That's right. But Turner doesn't allow the warden to institute policies simply by
and the
espousing...
Turner's second factor doesn't apply in this scenario at all, because that's, the second factor is whether an inmate retains alternative means of exercising a right, but there's no right being exercised here.
Well, it's tricky in this case because...
Tricky because it doesn't apply.
believe it
Maybe
does.
just focus on Bell if you think you can win there.
I will focus on Bell, Your Honor, but I do think Turner is informative to understanding this idea of when on its face an articulated, legitimate penological purpose is justified under the circumstances. And I think because this court and Florence
Now,
have
we're
talked
talking
about...
about strip searches at the Keene Mountain Prison.
Yes, sir.
And the Keene Mountain Prison is way out in western Virginia, correct?
Yes, sir.
It's not very far from the southern counties of West Virginia, or from the eastern counties of Kentucky. And is it the maximum security prison for the Commonwealth of Virginia?
That would be Red Onion, I think, in Wallens
They're
Ridge.
both out there. And Keene Mountain is a little north of Red Onion, I think. But they're both maximum security prisons, I think. And your fellow had been in there since at least 2005. I don't know how many years he's doing, but he's been in there a long time.
Yes, Your Honor, I'm not sure it's in the record how many years he was in there, or how long he had been in there.
And what specifically did the judge do wrong here?
Right, Your Honor. So what the judge essentially did was assume one fact that was an issue that for the jury to resolve in this case, and applied that fact in determining the reasonableness or the justification for these searches. And that
How
fact,
do you get a jury trial here?
well,
You gotta have a constitutional violation, and you have to have something that's not established. The constitutional right's not established.
right, Your Honor. Well, that
What's the
would,
constitutional right that's clearly established here?
the right to be free. Well, first of all, Your Honor, that a strip search involves an invasion of bodily privacy under the Fourth
Well,
Amendment.
the warden said that he had information that there were slipping drugs in the facility, and he wanted to stop it.
Yes, Your Honor. So a lot of questions there. Let me try to get to all of them, Judge King. First of all, it is for the jury ultimately to determine should there be material facts in dispute, whether there was a constitutional violation. That's how you get to a jury. And it's the appellant's position in this.
In a maximum security facility, the mayor, I call him the mayor, the warden has a lot of discretion. And
Yep.
here they only did this thing for what? 30 days or 60 days?
60 days.
That's right, Your Honor. Yes, sir, Your Honor.
6 years ago.
Right.
And you
Was
want
in
to try
2023,
the
Your Honor.
warden, in Abington or Roanoke, on this kind of a thing before a jury?
Well, Your Honor, I don't really think whether the question of whether or not,
Well, you just said something about having a jury.
I understand, Your Honor, but I don't
You're going
think,
to jerk the warden over to Abington? You know how far it is from Abington to Keene Mountain?
I understand, Your Honor, but I don't think the question of whether or
Or
not,
from Roanoke to Keene Mountain?
I understand, Your Honor. I don't think the distances between King Mountain and those cities are before the court, nor is whether or not it would be smart for a plaintiff lawyer to try a case in front of a jury in front of those.
Can I ask you a question, assuming that bail applies? What's your best argument that the warden or the prison hadn't offered a reasonable justification for this strip search policy?
Right, okay, so there's no justification for the second search. Basically, the court can look at the second search in making that determination.
And when you talk about the second search, these people are searched both before and, the inmates are searched both before and after they go into the Zoom meeting room.
That's right, Your Honor.
And while they're in the Zoom meeting room, they're in there alone with nothing other than a stool and a monitor that are bolted down, and they're observed the entire time, correct?
They can be observed the entire time.
And yet, they're strip searched a second time after they leave.
Correct.
Okay, now what were you going to say about that second time?
Well,
And how the justification is not reasonable?
and what else, one other thing I would add to that factual overview, which is undisputed largely, except maybe in terms of characterization, is that everyone that goes to the no contact visits passes through a section called picket control. And folks go to different places when they pass through picket control. Some of those places are for religious services, some of them are for educational services. A lot of them involve actual contact with people coming from outside the prison. The one that doesn't involve any contact with people coming from outside the prison are those who go to the no contact video visits. Everyone else is subject to strip search that goes through picket control, but everyone else that goes through picket control is not subjected to this policy of strip searches before and after no contact video
They
visits.
are doing that now. And when did they stop doing that?
Well, they stopped doing it about 60 days after they did it, but
They stopped doing it in 2020 or 2023?
yes, sir, but a
But
constitutional
they aren't doing
violation.
it. You just said that you're acting like they're still going on.
No, I'm not
And
acting like they're
And the
still,
warden did it of his own volition for 30 or 60 days,
yes, sir.
and that's it.
That's right, Your Honor, but the Constitution, this court's recognized that the Constitution can be violated in a matter of seconds. It doesn't matter whether it only happened for 60 days or 1 day. If it's a violation of the Constitution, which is a question for the jury in this case, it's a violation of the Constitution. That may go to damages, You know, but and certainly it could go to damages, the amount of time that it went on. But a constitutional violation that goes on for 60 days, I don't think this court wants to establish the precedent that it's okay for some number of days to violate the Constitution.
You were also talking about the picket control area. Didn't the warden also say in his deposition that he was concerned about drug smuggling through the holding area where the inmates are kept while they're waiting for their video visits?
No, Your Honor. I think that that Warden Hamilton's testimony in this case, as indicated by the record, is that he had received some vague information that maybe, I believe word was maybe.
He said intel.
Some vague intel. I'm saying vague.
Intel.
He said intel, that maybe contraband was being passed through the no contact video visits. There was no specific evidence that it ever had been, and in fact, no evidence was ever found when these searches were done that it ever happened. But that was, and what's important about that is Bell.
But couldn't that have been occurring in the holding area before they went into the no contact video rooms?
It could have been, but then it would have been discovered on the search going into the no contact rooms.
So your quarrel is really with the search coming out of the no contact room?
Yes, Your Honor.
Okay.
All right. And that's where Turner is kind of.
So you don't have a problem with the first search?
I don't think that the first, I don't necessarily agree with it, but I don't think that it's unconstitutional as a matter of law or anything like that.
And the problem with the second search is that the inmate was, number one, alone in a room, number two, in a room where there were only two other things, both bolted down, and number three, in a room alone where they could be observed the entire time. Number four, there's no contact with anybody else at all in that room. Is that correct?
And if I could just.
So, I mean, who's passing it? The guards? I don't.
Yeah, if I could just try to answer that question, I think it addresses all the points. First of all, yes, the warden has a legitimate interest in controlling contraband. But if that limitation was.
Not just a legitimate interest, he has the public interest.
Well, the question.
In controlling it. This is a maximum security prison.
I don't believe it's in the record whether or not it's a maximum security prison, Your Honor.
You
But
can say what it is. Tell me what it is.
but-
Keene Mountain.
That's not, the
And tell
point
me
is
what
whether
the
there is a
hell it
legitimate.
I mean, they put them out there in western Virginia and get them as far away from the populated centers.
And
I guess.
even if it's not in this
If we
record, I'm
can.
sure it's in the public record. What-
I understand, but the point is that Bell, whether it's a maximum security prison or not, does not give prison administrators indiscriminate leeway to search prisoners simply based on contraband. That's why there's a balancing test. The fact that contraband might exists in every prison, and of course there's a legitimate penological interest in controlling it, and that's why we have these tests to see if
But
searches.
you're not trying to stop this. That would be a request for an injunction, because it hadn't happened for years. And you don't want a declaratory because it's not going on. You want to get personal damages from the pocket of the warden for implementing this process for 30 to 60 days, correct?
I want, the plaintiff is seeking damages for the violation of his constitutional
From
rights.
the warden.
Well, I mean, there's a
Well, the
warden.
warden, and you got the guy who was working, Squire, too. And you want attorney's fees under Section 1988,
Well,
if you could get a couple of bucks from the warden.
Well, Your Honor, if the warden has violated the Constitution, or if Sergeant Squire did, and then the law permits the recovery of damages, and potentially for 1988 fees for the prevailing party. So we're just asking for what the law allows, Your Honor, in that regard.
You know, at the end of the day, you know, as we talk about whether Turner applies or the bail factors, and we can go through those factors on it, there's still that ultimate question of qualified immunity. And when you get to that, we just analyzed the constitutional violation, which you need for Section 1983, but the Supreme Court is very clear. You don't have to even answer that question. You just need to answer the question of whether this is clearly established. And to be clearly established, the Supreme Court has narrowed us down to almost finding cases just like this one. And I don't know of another case like this. Tell me a case that would, and I know the district court may not have gotten to it, but it seems to be pretty straightforward. I mean, we can dance on this all day long, but ultimately that question has to be addressed as to whether this was clearly established. And what is the case that would say if it is a violation of the Fourth Amendment to conduct a strip search of a person in a private setting by a member of the same sex, both before and after no contact appointments? Where is that case?
Well, Your Honor, I have 13 seconds. I still haven't answered Judge Thacker's question.
I
which
need you to answer
I would like to,
mine, no matter how many seconds you have, if you don't mind.
which I would like to do, Your Honor.
Please.
I
What
would,
is the case?
and Your Honor, I'll have to reserve some of my time on rebuttal for this. I see my time is up, but to answer Your Honor's
What is the case?
To answer Your Honor's question, I believe Bell, Turner, Logan, and even Robinette addressed that, give notice on this issue.
They
And-
they clearly establish the point you're trying to make. Answer, Judge Wynn, that's your answer?
I don't believe that
Well, you have to have a clearly established constitutional right.
Yes, Your Honor, and I do believe they answer that question. But Hope v. Pelzer teaches us that that right doesn't have to be so specific that the exact same set of factual circumstances have to be before the court, only that a prison administrator or someone working in that facility would have the opportunity to have notice to understand that they could be violating constitutional rights when they fail, when they implement a strip search policy that fails to have any rational connection to the stated purpose. And the second search is exactly that, which I will, when I get back up on rebuttal, try to answer Judge Thacker's question on specifically why that search is the problem.
Thank you very much. Ms. Switzer?
Morning, Your Honors. May it please the Court. Caitlin Switzer on behalf of the defendant appellees, Warden Israel Hamilton and Sergeant Squire. The district court correctly held in this case that the temporary strip search policy at Keene Mountain Correctional Center was reasonable and that the searches did not violate the plaintiff's.
Why was the
Fourth
second search reasonable?
Well, Your Honor, Warden Hamilton explained in his deposition that the purpose for the second search was to catch any contraband that may have been left in the room and not caught on the initial search and picked up by an inmate on the way out of the room. So when questioned about the need for the second search, he felt that it was necessary.
So in case their first search wasn't thorough enough, they didn't do a good, the jail missed something, and then they missed, they weren't watching on the video to see that people were leaving contraband in the room, so they missed that a second time, they're gonna strip search them a second time.
Yes, Your Honor, it's not about
I mean,
whether or not.
if the warden in the jail had intel that there was contraband being passed in these no-contact rooms where only a single inmate was in there at a time, it seems to me like that would make their video surveillance of that no-contact room increase. They had the capability to observe the individual the entire time they were in the room, right?
Yes, I believe it's in the record. There were
I mean, if they
cameras in the
thought
room.
that there was contraband being passed, you'd think that they would be looking at him, have their eyes on him that entire time they were in the room, rather than strip search him when they came back out.
Yes, Your Honor, the record does not, Warden Hamilton in his deposition wasn't asked, I think, specifically to explain why he chose to use strip searches versus perhaps an alternative means, but the test here under Bell isn't even necessarily whether there was another avenue to try to intercept this contraband, but whether
But
or
I
not.
guess it goes to, my question goes to whether this was a reasonable justification, given that the person was alone in the room, no contact with anybody else, no ability to move anything to hide any contraband, and the jail was watching them the whole time. I don't understand how it's reasonable then to strip search that person a second time. And I guess you're saying that the warden said it's because we might not have done a good enough strip search the first time.
Well, it's not necessarily about the strip search being good enough. I think he
I thought
explained.
that's what you said. They might have missed something the first
Well,
time.
of course, a strip search, involves only a visual inspection. So to the extent an inmate successfully hides contraband inside of their bodies or on their person in a way to evade detection in the first search, which is only visual.
Well, you wouldn't get it in the second search either, because they didn't do a body cavity search, did they?
Well, not necessarily, Your Honor, and that's what Warden
Not
Hamilton's.
necessarily what?
Well, Warden Hamilton explained that
Did they conduct a bodily cavity, all those things you just mentioned, where you could hide it? I thought it was a visuals, no contact type search.
Yes, it is. Sorry,
So
let
it's
me,
the same thing.
Everything was visual.
that's correct. It did not involve any touching or
But
inspection
the point I
of,
want to make clear is that the first search is no different than the second one, because there's nothing done in that second that's different than the first one.
correct, but it could be a different inmate. So what he explained was that the information that they had
A
is that.
different inmate?
The information that they had is that these inmate informants reported that inmates were leaving the drugs in the video visitation room for another inmate to then retrieve. So Warden Hamilton explained that his
I
thought
know,
was.
which is why they searched them before they went in the room, so they wouldn't have contraband, and why they watched them the entire time they were in the room, so they couldn't leave contraband for the next person.
Yeah, Warden Hamilton explained that he was concerned that they were missing the drugs.
Right, that
because-
goes back to them not doing a good enough search the first time, or being observant enough while they're in the room. And that may be a reasonable, I mean, maybe they want to, I mean, that's reasonable to want to assure that there's no contraband in the facility.
Certainly, and so, he explained that part of the reason, and this goes to Judge King's questions about the security level at Keene Mountain, he explained in his deposition, Warden Hamilton did, that Keene Mountain Correctional Center houses level 4 inmates and level 2 inmates, and that this video,
Well, what's
Picket
level 4 and
area.
level 2?
What's
Just-
that tell us?
well,
Yeah.
the different security levels with different restrictions on the
Okay,
inmates
so is
in this
level
area.
4 maximum? Is that the point?
I think there's also level 5 and level S. That's not in the record here, but it is a higher security level than level 2. And this area of the prison is one of the areas where inmates leave their housing units and have access to other buildings. And he explained in his deposition that the problem is that they had drugs being passed throughout the facility. So the goal here was in
And
response.
didn't he also say he was concerned about it passing in the holding area or something like that? Maybe I misread that.
Yeah, I don't have a specific where he mentioned he just references generally the video visitation area. So I can't say for sure whether he meant just the room or the entire picket area where Sergeant Squire also had the inmates waiting. So I don't want to put words in Warden Hamilton's mouth there and what he meant by that. But
The difficult part of at least that issue, I think, is Keene, because it seems as though the warden is relying upon this anonymous tip, whomever, to someone to say it's happening in a room that's a no-contact room. There's an officer in that room, and I cannot believe they don't sweep that room and check out to see what's in there. I don't know, and you guys just have this person there. The difficulty is in agreeing with you, how do we write a case that essentially wouldn't be saying, because the warden said it, it must be true, when there's really nothing other than the warden said this was happening, based upon an anonymous tip, which kind of takes you another step down the road because we don't know the credibility of that tip of the person who made it. And I mean, at the end of the day, all of those things are there. The courts go out of their way to try to work with prison systems on this to take the word of the warden. But here, it just seems a naked word of the warden. I have an anonymous tip that this is occurring, and yet the circumstantial situation is maybe they dropped it when there and left it there, maybe this happened, but none of that is really evidence here. There's nothing here that you can say other than speculation.
Sure. Well, I guess in response to that, I'd point the court to Florence and Johnson v. Robinette, where this court and the Supreme Court has said that a search in this context is reasonable absent substantial evidence in the record that the response of prison officials was exaggerated. And here, there's not substantial evidence in the record that this was an exaggerated response to the concerns that Warden Hamilton had, which,
So we have to trust the warden on the face of this record.
Here, the justification, certainly, because there's no evidence in the record of any other justification for the searches for a more nefarious
Were
purpose.
these anonymous tips? He said it was intel.
Yes, he said intel from the intel department based on information from inmate confidential informants. So inmates, he said multiple inmates had reported that they were using this area of the prison. And it's certainly true. I'm sure as I believe my colleague noted, these inmates aren't identified in the record. But the warden has an obligation to take this information and use it to stop the spread of the drugs if he can, because of course, he has an obligation to protect the health and safety
Right,
of the
but
inmates.
is this a reasonable way to do it? Rather than go in and sweep the room before you send the inmate into the room alone, instead of strip searching them when they come back out?
Yeah, I mean, it's defendant's position that, Warden Hamilton's discretion as a prison administrator that was necessary. And certainly that does require some deference from this court to the judgment of Warden Hamilton, but both this court.
And after he did it for 30 or 60 days, they hadn't found anything, and he stopped this thing.
That's correct, Your Honor. He testified in his
He gave his best shot, and it didn't work. That's right.
Yes, Your Honor.
And he's the warden.
He was acting.
And that's what they talk about, in this situation, you trust the warden in an institution like this, with these kind of prisoners. You have to.
Yes, I mean, he was acting based on specific information and a specific concern.
But to get to his trial, your colleague there wants a trial of the warden to be held over in Abington or Roanoke, 150 miles from this prison, I think. You got to get past a qualified immunity claim, as Judge Wynn mentioned. And how could you ever do that in this situation?
That's correct, Your Honor. I mean, to answer Judge Wynn's question about what case would have put the warden on notice that this was unconstitutional, the answer is there isn't one. The weight of authority is that prison officials are given substantial deference in this area, that he has an obligation to
Problem
curb.
is, the district court never reached that issue. We didn't get to the qualified immunity issue, but I'm not sure we need to send it back for it to do it if it's a question of law, particularly when you're addressing the clearly established prong of that. The Supreme Court has put us in a position of, just saying, the whole constitutional issue we spent all the time on, the court is permitted, and it even seems like it's encouraged to just say, well, even if it was violated, it wasn't clearly established. The big problem I find with that is it won't ever be clearly established if that's what you do in every case. When are you going to look at it and determine whether that is a constitutional violation or not? But at the end of the day, even if we do, there is still a qualified immunity question here. And I mean, it seems pretty clear to me where the Supreme Court is going with that. I think we could go all day long and say this is a violation and it's the worst thing in the world, but at the end of the day, this thing doesn't seem to be able to survive the clearly established prong of qualified immunity.
That's correct, Your Honor. And this court, as you noted, can decide that in the first instance.
Have you argued that we ought to skip the constitutional violation or assume it and then go to the clearly established prong?
No, Your Honor. I mean, we're asking the court to find
You're trying to get us to decide it on the first prong.
that this is
And
reasonable.
that's where we are.
Yeah.
I mean,
Yeah.
all he's got left is the 1983 claim
That's correct.
against the warden, against Mr. Squire.
That's correct.
But he wants the warden.
And it's gonna come up. I mean, even if we rule in his favor, it's gonna go right back to that court. That's the district court, and there's no way you're not gonna address qualified immunity. There's no way you're not gonna eventually get this up. So it seems like, we're having a wonderful discussion, but that's before us, and no, you didn't bring it up. And what perplexes me on these cases, when you bring them, is why didn't you ask the district court to do it?
Well,
I mean, he stopped and didn't go there. He says, Your Honor, if you would, we would ask that you also address the second prong of this, and then it puts it clearly before us, but there are cases in which we have addressed this because we've determined that really is a question of law.
That's correct, Your Honor, and I mean, Johnson v. Robinette is one of those cases. There were 7 strip searches at
But
issue
you're about to
there.
tell me why you didn't ask the district court to do it.
Well, we raised qualified immunity in the district court, but as Your Honor knows, the district court
But I mean,
elected
gave
not
its
to
rule.
reach that.
I mean, district courts are pretty open to hearing, asking you, just at least as, Your Honor, we raised this, would you? And then he could say, no, I'm not gonna do it. Oh, yes, I will. But it seems to me that that's dispositive of this case. And we're up here, and we can go round and round all day long on a constitutional violation for which, if, depending on how we rule, it's pretty important law, the constitutional aspect of it. But at the end of the day, for this client, it's gonna end up in qualified immunity, and the question is whether it's clearly established. And then I don't think seeing Bell and Turner has clearly established is gonna be enough. If it did, there are a whole lot of cases that are clearly established that the court has held otherwise.
That's correct, Your Honor. It's too high a level of generality here just to say that the Fourth Amendment itself, or this general right to be free from unreasonable searches and seizures put the defendants here
And
on
what's your
notice.
best case that we just trust the warden regardless of what the warden says, regardless of how unreasonable the justification may be?
Well, Your Honor, I think the most helpful cases here are Bell v. Wolfish and Florence v. Board of Chosen Freeholders from the Supreme Court, particularly Florence, because there the challenge was to an administrative policy of searching every arrestee upon admission to 2 different jail facilities, regardless of any suspicion of that individual inmate, regardless of what the offense was that the inmate committed or was being arrested for or suspected of. And the administrative policy was upheld because of, as the court emphasized, the concern for curbing contraband in a prison, and that the court shouldn't place
And
itself.
I understand that concern, but it doesn't have to, it can't simply be a justification standing alone. It has to be a reasonable justification.
That's correct, and I mean, our position here is that the warden's explanation, to the extent he was given an opportunity in deposition to explain his thought process behind being concerned based on his experience with how small the drugs are that these inmates are smuggling and the creative ways that they can hide them places on themselves. Sergeant Squire testified, he's seen them pass things to each other underneath doors, a lot easier than you would think. So based on his experience in the prison, that's his explanation. And we posit that that's a reasonable explanation, and that based on the precedent from this court and the Supreme Court, that's sufficient, because that determination or that discretion is necessary so that wardens have the ability to make judgment calls without necessarily having, where discretion is necessary, having to choose between taking measures that the warden believes is necessary to protect the health and safety of the inmates versus not strip searching an inmate on the way out of a room and only strip.
Why did he stop doing it? Why did he stop implementing the policy?
Yeah, he testified in his deposition that he did not recall, but based on the fact that no contraband was found, that he thinks that's probably why he stopped, because his particular purpose here was just trying to intercept the contraband that they'd seen a spike in. They're in particular, defendants presented evidence below of an increase in drug overdoses.
See, that's what makes this case somewhat more difficult. I mean, if he was out in the yard or there was this opportunity for it, it seems really low that an inmate who goes in a room, just this room, got an officer sitting in there, knowing that he's in there. He has no contact. It's a video type contact with the visitation. And he comes out, he strip search. And that's kind of hard to understand. I know you can probably posit, well, maybe he had something on himself and he gave it to someone. Well, that's not in that room. I don't know how that happens unless they walk, but it seems like, and Judge Stacker alluded to this, that, you know, if that is the problem of being in a hall, then don't let them walk down the hall together. I mean, it seems like it's coming from somewhere else. But to simply go into a room, look at a video and come out and be strip searched, you know, and the Supreme Court has made it clear that prisoners do have that right. That's the Supreme Court law says you can't just search a person, strip search them for nothing. I mean, that violates even their rights. I mean, they have that Fourth Amendment right on it. So that's the problem. And as Judge King alluded to, writing that opinion is difficult to get there without concluding, well, what you got to do is say the intel people apparently talked to somebody and then relate it to the warden, who then implements this policy that the defendant contends is in violation of the Fourth Amendment. And I don't think we want to write an opinion to say that he can just make that without anything else,
Your Honor,
other than speculation.
it's true that, you know, for no justification or an impermissible justification, inmates absolutely have a right to be free from searches that are targeting, harassing for the purpose of intimidating them.
Yeah, that's given law.
But-
That's a given law.
Absolutely, but there is no evidence in this record that the purpose for the searches was for anything other than a targeted concern about the specific room. And that was in response to evidence in the record of substantial drug overdoses throughout the prison. And so,
What you say is, it wouldn't be speculation. The warden credited the information and adopted this policy, maybe as an experiment or something, but he did it for 30 or 60 days. They don't even know how long it lasted.
yes, Your Honor, he did it.
And then he terminated it, and it was unsuccessful. And they want to find him liable to the prisoners for this kind of thing?
I see my time has expired,
I mean,
Mayor.
that's what, but that's the lawsuit here. And it's in the appeals court of the United States. Figure it out.
Seems like your response is, I agree with that.
That's correct. Thank you, Your Honor.
And we appreciate your help. Mr. Carroll?
Yes, sir. May it please the court. Respectfully, I don't think that the Constitution permits wardens to experiment if those
Well,
experiments.
that's what the question is here. But as my friend Judge Wynn mentioned, it didn't go off on the constitutional determination. It didn't get to the second prong.
Yes, sir. I just think the wardens are afforded deference under precedent, but not blind trust. And I really want to answer
And
Judge.
they have to be accorded deference, because they're like the.
Deference, but not blind trust, and that's why the Bell and Turner
Well,
test
it's not blind
exists.
trust. He testified that he got the intel. He testified that he got the intel, and he was under oath.
Yes, sir. And Turner creates a rebuttal.
But you want us to assume that he lied about it.
I'm not saying that you don't have to assume that he
Well,
lied.
well,
No,
then we assume he told the truth.
Your Honor,
If you
No.
assume he told the truth, then you're stuck with that.
Your Honor, I have short time. I'd like to be able to answer your
I think what you're
question.
saying is not that he lied about that he received this intel, but that his response to that intel was not reasonable.
Essentially, it was exaggerated and therefore unjustified. Turner tests the deference. Bell tests the search. Here's why the second search is so unjustified, based on the facts as we understand them.
The second search is you think that's your best argument.
Yes, sir. And this is why.
What's your best argument about being the clearly established constitutional violation?
Well, I'd like to answer that one too, but I think it's important.
You don't have any argument about that.
I do have an argument about that, Your Honor, but I think it is important for the court to address the constitutional issue so there's guidance. And so I'd like to address that part of it, and then I'll address the qualified immunity with the time that I have. The inmate is searched going in. They're strip searched going in. The only way they can take contraband in is if they have it in their body cavity. It's admitted that the strip search doesn't get that. So it's possible somebody has something in their body cavity. They go into the room. the visits are staggered. There's no possibility for any contact with any other individuals as they're going in and out of the rooms. They're escorted to the room by security. They're locked in the room. The room has a bench bolted to the floor and a TV screen bolted to the wall. It has live camera surveillance that's possible and a window in the door. The only way that contraband gets into that room is it's in the body cavity. That would require that the inmate then takes their pants off, I suppose, and removes contraband while on video and possibly being monitored
One
through
would
the
think the
window.
jailers would notice that.
You would think. And if they didn't notice it, where can they hide it? On a bench, a stool that's bolted to the floor. I don't know how. They would have to be able to tape it to the bottom of that, or I suppose stuffing it behind the TV screen on the wall. That's it. If an individual comes in, a correctional officer comes in to escort them out, all they have to do at that point is look to see if anything has been put behind the TV screen or under the bench. And in fact, that's a more effective measure because you would actually find it then, and you wouldn't find it on the way out with another inmate, presumably, who got it and put it inside their body cavity. That would be the only way for it to be detected on the way out. So the second search, not because the warden is lying and not because the warden, is trying to harass or sexually assault anybody or anything like that. The second search just doesn't serve any legitimate penological purpose. It just simply does not.
So it really goes to the question, don't worry about your time. You mentioned that we sometimes let litigants or lawyers stand up here for a long time. Judge King will allow you to talk as much as he wants you to talk, or a list, but so don't worry about that. We're gonna satisfy ourselves on that. But in this case, it just seems like it becomes a closer case when you look at the totality of the circumstances and describe, first, there is a huge problem. You're in a prison setting. They are exchanging drugs. Prisoners are as creative as anything in the world, more creative than lawyers, and can do all sorts of stuff. The warden gets information. It seems implausible. I will agree with that. It does. But is that the test? If the warden believes it and that this would help, it seems as though the ultimate question may come down to, is it a reasonable thing for him to implement a policy? And the temporalness has been emphasized, but it seems to me if you do so for 60 days or 90 days, the lesser period of time, it seems to be, more a tighter situation. But your case is built around a fact, which I think the facts are there. It seems like it's very implausible that you can do this. But this warden is trying to deal with a major problem there. This is where the courts go on. This is the kind of language you're getting on it. And so get back into, I don't know why the Supreme Court decided that you don't even have to answer this question. You can go to that clearly established. I brought that up several times. Supreme Court's done that. I actually think it's for cases kind of like this, where it is so close that if you answer that question, you're going to make a law that may just be interpreted as whatever the warden says. And the court ought not be put in a position like that. So you don't have to. You can just say, assuming for the sake of argument it was a violation, it wasn't clearly established. End of day. Sometimes you do want the question answered. Sometimes you don't, because it may allow you in another case with a different set of facts to escape the law and the precedent that can be set in this case. You disagree with that?
Sir, first of all, I wholeheartedly agree that this court is bound by the two-step process. But I also think this court has a responsibility for the reasons that you point
But
out.
I want to be clear that when you say bound by the two-step, the Supreme Court
Qualified
has made it
immunity
clear,
process.
we don't have to do step one. That's the point I'm making. The Percy case makes that very clear.
I agree with that as well.
And that was the basis I'm telling you. I didn't understand it, to be honest, but when I see a case like this, where it's so close, it kind of makes sense that you might not want to deal directly with that question now, because this is not the case. Sometimes you get bad facts that will make bad law. And if that's the case, then maybe going to the clearly established, which ultimately is going to be reached. Whether you win or lose it for this client is going to be reached.
This is a great case. You're right. You're right about that. The court says you may go to the second step, but not that you must go to the second step.
Well, they said Saucier is the name of the case. It says we can decide it on either prong first.
Yes,
We can
sir.
go whichever prong we want.
And I encourage the court to
We can
decide.
do that.
I encourage the court to at least decide the constitutional prong here for two reasons. One, that's all the district court below addressed. And so it's a great opportunity for the court to do that. Two, the facts are very good that this second search, yes, implementation of searches, even if it's implausible, fine. But there's no point in the second search. It doesn't serve any legitimate penological purpose.
And even though it was only in place for 60 days, am I correct that he was strip searched 26 times?
He was strip searched 26 times, and some of his companions were searched more, the record
But
demonstrates.
it was, that means it was twice when it occurred, so it must have been 13 times.
It's 13 non-contact visits with his mother, Your Honor.
13, yeah.
And
they said 30 to 60 days, like they didn't even know how long they'd tested this thing.
well, he didn't even know whether it had any impact or not, because he testified that he was unaware whether he
You're
even
talking about
reviewed the
the warden.
data. Yes, sir.
That's right. You got the warden's deposition here. That's a big step.
And the second factor, Your Honors, on that point of Turner,
But he terminated the thing when it didn't produce any results.
he terminated it. He doesn't know why.
He tested it out, and it didn't work. It didn't find anything.
You said he didn't know why he terminated it?
He said he didn't know why he
Said he
terminated it.
didn't remember it.
He didn't remember. He
Didn't
didn't remember
remember.
whether or not he'd ever
He didn't
reviewed any.
remember.
He didn't remember whether he'd reviewed any documents as to whether it had any impact
He
whatsoever.
didn't remember.
He didn't even know whether any contraband had ever been found on any of the searches. So that, I think, reinforces that it didn't really serve a legitimate penological purpose if the answer is, I don't know whether it did anything or I didn't even bother to really look. And just to Judge Thacker's point, I'm sorry, I'm taking some liberties with Judge Wynn saying not to worry about my time.
Well, I'm
But-
not in charge, Judge King is in charge.
The second Turner
Well, I
fac-
should be in charge, but these lawyers just kind of run over me.
I'm so sorry, Your Honor. If you want me to stop, please tell me. I want to just answer the qualified immunity question really quickly. But the second Turner factor,
Well, you can't answer it.
I can, Your Honor. You can't, the exercise of the right to bodily privacy means you have to
Well,
choose
you-
between visiting with your mother and being strip searched for no reason. That's the second Turner factor. And the qualified immunity test there has to be a justification. And there are plenty of cases, even Robinette, it says there can't be an exaggerated response. The right was clearly established at the correct level. Strip searches must be reasonable under the circumstances. Bell requires the need for a particular search. Turner requires a rational connection rather than an exaggerated response. And Logan made clear in this court that you can't just indiscriminately search people when there's no discernible relationship to a security need. And that involved a case where a person, unlike Florence, a pretrial detainee was on a DUI, but wasn't going into the general population, wasn't having contact with other inmates, and this court instructed, which is still good law in Logan, that there was no rational justification to search somebody who
But
didn't have
inmates
other...
in penitentiaries have their rights circumscribed.
Yes, sir, that's right. It's not a pretrial
To a very
detainee case.
substantial extent. And your time is about up.
Yes, sir, I think my time's well up. I
And
appreciate what
we-
courts...
We appreciate your work
Thank you, sir.
very much. And we appreciate the Assistant Attorney General's work. And glad to have you all here.
Thank you very much.
And we'll come down and greet you as we do in our cases, and then we'll call the next case.
All right, we'll call the last case, number 226411, Stephen Roberts versus Mark Ingleke et al.
Thank you very much, Madam Clerk. Mr. Corson, good to have you with us, sir.
Good to be here. Thank you, Your Honor. And on behalf of the Wake Forest Appellate Clinic and under Local Rule 46, it's my pleasure to introduce the Student Counsel who are appearing here today. Katie Kesters will be doing the opening argument, Nayeli Selkis the rebuttal, and also with us is Will Boyce, who is on the reply brief. Thank you all very much.
Very good. Thank you all of you. And we're good to, it's great to have you with us. Let's see, and Ms. Cloisters, you're up first. Be pleased to hear from you. You represent Mr. Roberts?
Yes, Your Honor. May it please the court, good morning, Your Honors. Katie Kesters on behalf of Stephen Roberts, along with my co-counsel, Nayeli Selkis.
And he's in a prison called Red Onion?
Yes, sir, he is in Red Onion State Prison.
Yeah, you know where that's located?
Your Honor, it is in the state of Virginia. I'm not sure exactly where in the state of Virginia.
It's way out there, and
It's in the.
you're in
the
Richmond
boonies.
now, and it's way out there.
Yes, sir.
It's almost, I don't think it's as far as Keene Mountain, but it's almost in Kentucky and West Virginia.
Yes, sir, it's way out there in
Red
the
Onion.
western area.
You know what kind of a prison it is? What
I
kind-
believe it's maximum security, Your
Pardon?
Honor. It's a maximum security facility.
It's maximum, it is the maximum security?
I'm not sure if it's the, but it is a maximum security
maximum
facility. Yes, Your Honor. And with the court's permission, I
So
would.
that would mean it has what we might call the worst prisoners that the Commonwealth of Virginia holds.
They've been determined to be the most dangerous that the Commonwealth might
Yeah.
hold. And so with the court's permission, I would like to reserve 5 minutes for rebuttal
I
from my
guess that whole
co-counsel.
colloquy there it brought something to mind is you've never seen your client.
No, Your Honor, I have never seen my
I
client.
wonder if Wake Forest would consider that when you represent someone, it would be kind of nice to, I guess maybe video or some kind of way you've actually seen your client.
Yes, Your Honor, it would be nice, but Professor Corzine speaks regularly with Mr. Roberts and can pass along his conversation. And
He has been there. He
Ye-
knows.
Yes, sir, he
He
speaks.
knows you're here for him.
Yes, Your Honor, he's
speaking
aware
for
that
him.
we're arguing
And
today.
I'm sure he appreciates it.
Yes, Your Honor. So today I would like to focus on the free exercise claim and anything else the court would like to discuss. But before turning to the free exercise claim, I'd just like to spend a minute or so talking about the basis for these claims and what exactly happened to Mr. Roberts. So he is an Orthodox Sunni Muslim who practices Ramadan fasting, and he also follows the Orthodox Jewish standards of the kashrut. And the only diet at the Red Onion facility that comports with his religious dietary needs is the Orthodox Jewish kosher diet, or the OJKD, as is referenced several times. And on the
So
first,
this whole case is about the food served in the Red Onion cafeteria.
yes, Your Honor, it's about the OJKD that Mr. Roberts was on that comports with his kashrut beliefs, as well as the ability to receive that diet on the Ramadan fasting schedule. And so that 30 days of Ramadan, whether or not he was able to receive. And in 2020, which is the year of the issue here, he was not able to receive that OJKD, his religious diet, on the Ramadan fasting schedule. He requested on the first day available on March 10th to receive that diet. He received 3 separate forms of approval from prison officials. And then the day before Ramadan started, April 23rd, he was approached by a VDOC counselor who told him he either had to choose. He could either participate in Ramadan fasting and remain and change his diet to the common fare and remain on that non-compliant diet for 6 months, or he could not participate in Ramadan and not participate in Ramadan fasting, which is a core tenet of his Islamic faith, and receive the
Are you saying the
OJK.
first request was in March of 2020?
Yes, Your Honor, March 10th of 2020, that's when the Ramadan request forms came out. So that's the first available date that he was able to go through the official process. So about a month and a half before the beginning of Ramadan is when he requested the Ramadan fasting. He had also been on Ramadan fasting since he arrived at Red Onion in 2006, so he had been on
So
it
the
for
fact,
years.
the diet wasn't the issue, it was the schedule of the diet, as I understand it. The prison said they couldn't give it to him within the scheduling that would allow him to participate in fasting, which is one of his religious tenets, particularly during Ramadan.
Yes, Your Honor. So he was able to receive the OJKD for the remainder of the year, but the prison told him that the OJKD was not served during Ramadan, so that he would not be able to receive that diet during Ramadan.
They gave him options.
They gave him options that were non-compliant with his religious beliefs.
Was one of those options compliant?
No, Your Honor. So the two options that were presented to him at the time of the denial were either to stop receiving the meals that comported with his religious diet, so he would go back to the common fare diet, which does not comport with kashrut, which are his religious beliefs. So that was the first option. He would have had to stay on that diet for 6 months, and at that point, he then would have had to request to be put back on the diet. So he would have been out of compliance with his religious beliefs for 6 months if he had chosen that option. The second option that they gave him was to remain on that diet, the OJKD, but to not participate in Ramadan fasting for that month, which Ramadan fasting is a core pillar, one of the 5 pillars of Islam, and so a very central part of his belief system. And so those were the two options that were presented to him at the time.
He wanted a Jewish diet during Ramadan.
Yes, Your Honor,
And on the face of it, for folks that don't understand some of this, it doesn't make a lot of sense. And I think maybe the district judge indicated that what I said, that it didn't make a lot of sense. But these are the facts.
Your Honor, the district judge did find that there was a constitutional violation here, and part of that was that these were the sincerely held religious beliefs of Mr. Roberts. So whether or not the diet makes sense or seems to make sense in our heads.
He said it violated one prong of the First Amendment.
Yes, Your Honor, he said that that the free exercise clause was violated. Yes, because
of the First Amendment.
Yes, because
Judge Jones.
Yes, Your Honor.
Of the Western District of Virginia.
Yes.
A very able judge, and he wrote a comprehensive opinion.
Yes, Your Honor. He decided that there was a constitutional violation here, that there was a sincerely held religious belief of Mr. Roberts, and that there was a substantial burden. And so he held that there was a constitutional violation. What he did not find was that there was a clearly established right.
So he's back on that. We talked about that some already today.
Yes, Your Honor.
A clearly established prong. You're very familiar with.
Yes, Your Honor, and we would argue that it is clearly established here, and that the prison officials were
Your argument is that the district court defined the right too broadly, is that correct?
The district court defined the right too narrowly, Your Honor.
I'm sorry, too narrowly.
Yes, Your Honor, and so what we would contend here is that the right at issue is whether Mr. Roberts had the right to receive a diet consistent with his religious scruples.
And how did the district court define it?
The district court defined it the same way that the defendants are asking for here, which was a Sunni Muslim inmate's constitutional right to receive meals supervised by an Orthodox Jewish rabbi as part of his Muslim Ramadan observance.
Oh, right, you couldn't get more narrow than that,
And that's
really.
very narrow, Your Honor.
And you read that from his opinion?
I believe what I'm quoting there is from the appellee's brief, but they were quoting the district court. So it was something very.
I just want to make sure we get, when we refer to the district court, that we get his words correct.
I am quoting the appellee's brief. I believe they were quoting exactly what the district court said, but the district court defined it essentially the exact same way as what I just read.
But your argument is that the right at issue is the right to a nutritionally adequate diet that's consistent with his religious beliefs.
We're saying a diet consistent with his religious scruples. And so that's the definition from this court's precedent in Lovelace v. Lee in 2006. So we're not asking this court to apply a novel definition, but just to apply its own definition from Lovelace. And this court has used that definition several times since. For example, Wall v. Wade in 2014. Both Lovelace and Wall v. Wade involved an inmate who was attempting to practice Ramadan fasting. And then recently in an unpublished case, Coleman v. Jones, this court in 2022 applied the nutritionally adequate diet consistent with religious scruples, and that was specifically looking at whether the common fare diet was nutritionally adequate. So
when I first looked at this case, I had to really go and try to figure out what was he asking for, because it seemed a little inconsistent when I saw the Muslim Ramadan and then at the same time the Orthodox Jewish diet. It seems like, well, those are kind of two different things. And typically, you don't get a request like that. It is somewhat unusual, but my guess it's there, you have to, in the public domain, it's not unheard of, but it's unusual. And then the prison system itself has to do this within weeks, accommodate the religious followings of his various individuals. It could be many, many. And you can imagine if you had 100 of these things out there. So when you get down to it, the question then becomes, and I'll jump ahead, ultimately they did correct it. They were able to do it at some point in time.
Yes, Your Honor.
But it seems to me in terms of, and I'm not sure the district court even did a Turner analysis on this, when you get to the penological justification part of this, it seems to me that when a prison is faced with that kind of, I would call it a different type of request. I think we can all agree that.
Yes, Your Honor.
That it's not a typical thing to ask for one religion and another to do that, the two together. That, under these circumstances, to not be able to move forward and seek to try to work with it, it seems like maybe that cuts against you a bit.
Yes, Your Honor, I take your point, but there weren't any real justifications for the denial. It was about a month and a half that they would have had to accommodate this request. And the defendants, although not making this argument below, have now asserted that they would have had to create an entirely new menu. So there are all these things they've listed in the brief that
What's the month and a half? The whole thing or the notice?
Your Honor, when he requested on March 10th, Ramadan began, I believe, on April 24th, so it was a month and a
So you're talking about
half.
the amount of notice?
Yes, Your Honor.
All right.
And so in that
And
month.
he was already receiving the OJKD
Yes, ma'am.
diet, right?
He had been receiving the OJKD since the summer of 2019.
Right,
And
that's not the problem. They could do that, they'd proven they could do that, that's what he'd been receiving for years. The problem was they wouldn't give it to him on the schedule that would allow him to fast for Ramadan.
Yes, Your Honor, that's the issue. And so when the defendants are citing all of these things that they would have had to do, we would just contend that that's untrue. The OJKD was already a diet that was served in the prison. It's already something that they knew was nutritionally adequate, that complied with the standards of kashrut. It was already served. They were already prepared to serve meals on the Ramadan fasting schedule. They had the staff to do that. They knew that they would be compliant with the Ramadan fasting schedule. All that Mr. Roberts was requesting was to take those meals that they already have and simply serve them on a different schedule.
So
There's
you argue that they lied to him?
No, Your Honor.
They said they couldn't comply, they couldn't do what he wanted to do?
No, Your Honor, and at the time of the denial, they didn't assert any of these things, any of these resource constraints or things like that. They simply said,
They didn't argue that to the district court either.
no, Your Honor. They did not state that at the time of the denial. They did not argue it to the district court. Now, in the briefing, they're asserting all of these things that they would have had to do, but that's not what Mr. Roberts asked for. He didn't ask for a new menu. All of these things wouldn't have to have been created. He simply asked them to take already existing meals and serve them
So
on the Ramadan
what do you
schedule.
want us to do?
Your Honor, first, we would like you to apply the Turner factors. Judge Wynn is correct in noting that the district court did not apply the Turner factors, simply found the constitutional violation. So we'd like this court to apply the Turner factors. But even so, even if the Turner factors are not applied here, there are disputes of material fact, and summary judgment is not appropriate at this point in the litigation. So we would ask you to reverse and remand.
What remedy
For
you seeking?
what? That's what I want to know. What do you want us to do? What would we, remand for damages?
Yes, Your Honor.
You want to,
Under what?
for a trial?
Under his 1983 claim and the suit against the prison administrators in their individual
For
capacity.
violation of what constitutional act?
We have contended free exercise, establishment clause, and equal protection. So for any of those three constitutional issues, to receive damages under 1983.
So you think we should apply the Turner test to the establishment clause?
The Turner test definitely apply. There's a bit of confusion in the case law about what the Turner factors apply to. They definitely apply to the free exercise clause, which is the primary argument that I was discussing today. They definitely apply to the free exercise clause. They seem to apply to the equal protection clause, but they have never been applied to the establishment clause.
Well, I don't know how the Turner factor is going to help you. Tell me how that's going to help you to apply the Turner factors here.
Well, we would contend that the district court reached the correct conclusion in determining that there was a constitutional violation, but without considering the Turner factors, we do concede that the Turner factors do apply to free exercise litigation.
Well, I thought the district court ruled against you on qualified immunity.
Yes, because of the clearly established framework. In the district
And
court.
that's because, in your view, the district court defined the right too narrowly.
Yes,
and
Your
that's
Honor.
So you would have us
Issue.
reverse the district court
Yes, Your Honor.
on the clearly established.
Yes, Your
law.
Honor. We would have you reverse.
And hold a trial for damages
Yes, sir.
against the warden?
Yes, sir. Against all of the parties that are named in the brief. So
Well, you gotta,
I believe it's the
how many
director
of
of
them are
foods.
responsible for this? I mean,
The-
who you, or do you need more discovery? How do you figure out what you're gonna have a trial, and where are you gonna have it?
Your-
Where are you gonna have this trial?
Your Honor, I see that my time has expired. May I
You
answer your question?
answer questions as long as you get them.
The trial, I believe, would be in the Western District of.
Where?
of
In the Western District of Virginia.
Yes, Your Honor.
So either Abington or Roanoke, probably. Judge Jones used to be, I don't know whether he's still working hard or not. He's maybe a senior judge. He's been around a long time. He's a terrific judge. He went to Duke, as a matter of fact, I mentioned to you, he's one year of North Carolina
Yeah.
Law School.
So I believe,
He's
Your
a
Honor.
very learned fella.
I believe it would be held in the Western District, and the defendants we have here are a VDOC counselor. We have the director of food service who gave the direct order that he would not receive the diet.
It's like a kitchen sink. You're trying to hold everybody liable for this thing. It's never happened again.
That's correct, Your
And
Honor.
it's probably never gonna happen again.
And the fact that it happened again,
But and they're gonna have a jury down in West Virginia trying to figure out how much damages to assess.
yes, Your Honor, and in terms of the damages, he was sick. There was mental anguish throughout the entirety of him not being able to comply with his own religious beliefs. So that's what we're asking.
And how many, and those dangerous prisoners are gonna have to be moved around if they're gonna go to trial down there in Western Virginia. This is not a,
Well, Your Honor, we are asking for him to have the opportunity to present his case in front of a jury for damages for what was a fairly egregious constitutional violation to force this individual.
Maybe on rebuttal, to make it clearer in terms of the damages, I think it's pretty clear under this Religious Land Use Act, you don't get it in the official capacity. We agree to that. So I'm not sure it's been fully decided, totally decided, you get it in an individual capacity. I don't like to guess or predict what the Supreme Court's gonna do. There's a case called Lander. I don't think it's
Right.
gonna go there.
Right, and so if Landor does not go in the favor of Landor in that case, then he wouldn't be able to receive damages under our LUPA, but I believe he would be able to receive damages under Section 1983 in
you
their
think you
individual
got damages
capacity.
under 1983, that's what, yeah. RLUIPA, probably not.
Yes, but under Section
But
1983.
1983, you think you got a damages claim if you get past the qualified immunity second prong.
Yes, Your Honor. So if there are no other questions, we would ask this court to reverse summary judgment and allow for discovery regarding the VDOC's dietary policies.
You want discovery?
Yes, Your
I
Honor,
thought
that was,
I thought you had discovery, you were gonna go to trial.
Mr. Roberts requested discovery under, regarding
Oh, you had a
VDOC's.
request for discovery,
Yes, Your
but
Honor.
but you said you got turned down.
Yes,
So you want us to reverse that too?
yes, Your Honor, to grant discovery regarding the history of the VDOC policies that would show essentially that they knew the diet wasn't compliant and that denying Mr. Roberts this
So you think the
diet.
judge erred in that regard also?
Yes, Your Honor.
Or have you mentioned everything that he did wrong now?
I believe so, Your Honor. Yes, the main argument that we're putting forth here is that the judge erred in not correctly applying clearly established framework. Thank you, Your Honors.
Thank you very much. And Ms. Phillips?
Good morning, Your Honors. May it please the court, my name is Michaela Phillips and I represent the VDOC officials. This case is about a 6-week window between March and April of 2020 and what a prison reasonably could and could not accomplish within that window. Mr. Roberts asked for the first time on March 10th to combine 2 religious accommodations that VDOC had not foreseen would be paired together. First, the kosher diet, which requires rabbinical supervision and off-site kitchen preparation, and second, the Ramadan fasting schedule, which requires meals timed to astronomical twilight,
And
sunset.
so he'd been receiving that OJKD diet since 2019, correct?
Yes, but
So
when,
your first prong, you're already doing that, so what's the problem?
the problem is that under the Turner factors.
So then it's the second, you can't give it to him on the Ramadan schedule.
Right. At the time, there was no, so part of the Ramadan schedule is the meals time before twilight and after sunset, and then they also get a 4-hour meal bag that is given after dinner. And the problem at the time is that VDOC did not have a meal that would be safe to eat within that 4-hour window that they could just take with them. So that was the problem. But VDOC has since revised the policy. Mr. Roberts has been getting his Ramadan meals, his kosher meals on a Ramadan schedule since 2021, and that policy is still in effect today, which the court can take judicial notice of.
This March the 10th was 2020.
Correct. And under the Turner factors, the VDOC had a serious interest in keeping inmates safe and healthy, and they simply just could not create a safe, fasting compliant meal option within that 6-week window. There are several steps.
So you're arguing that they had to come up with a new menu within this 6-week window?
Mr. Engelke's affidavit says that it needed to be reconfigured, but the new aspect is simply the meal, the third meal that would be shelf stable within 4 hours and safe to eat.
And you argued that before the district court?
I believe so, Your Honor.
That was the bag that was supposed to be refrigerated.
Correct.
Wasn't there an affidavit from appellant that he had received shelf-stable menu items before, during the years that he was on this OJKD diet?
I believe his affidavit said that that is the accommodation that was made for Ramadan 2021 and thereafter, that his position is that they could do it because they have done it since. But in 2020, when faced with this request on 6 weeks' notice, they didn't know if they could safely do that in that time.
Now, did Judge Jones rule the way you're telling us here now?
Yes, he
The
concluded.
district court found things the way you cited them?
I believe so, Your Honor.
Okay.
He found a factual finding that there was a shelf-stable meal bag, but that the district court found that, crediting Mr. Engelke's affidavit, that it could not be provided
That it
at
couldn't-
2020.
They couldn't satisfy the requirement.
Correct.
So under the ruling of Judge Jones, there's no need for a trial.
Correct, Your Honor.
There's
And
no liability.
right, and this goes back to the qualified immunity analysis too. At the time, there was no clearly established law from either the Supreme Court of the United States, this court, or the Supreme Court of Virginia that would have created, or that clearly established that a Sunni Muslim inmate had a constitutional right.
That's if you define it that way, that narrowly. That's very specific to this situation, very narrow. Why wasn't the clearly established right, the right to a nutritionally adequate diet that is consistent with his religious beliefs?
I have 2 points to that, Your Honor. Under the Supreme Court's case law in White v. Pauley, Mullen ex Brosseau, the court has stated, and this is a direct quote from White v. Pauley, the clearly established law should not be defined at a high level of generality. It must be particularized to the facts of the case. And the facts of this case...
But not so narrowly that it only would apply to this one singular situation.
Well, Although in a general circumstance, the prisoner has a clearly established right to the diet consistent with religious scruples, the court also considers the Turner factors. And in Wall versus Wade, this court said, absent a legitimate reason to the contrary, they have this right. And in this particular circumstance, it was justified and reasonable that they wanted to be able to provide a meal that would be safe and healthy enough for the inmate to eat and use their resources effectively. So within a condensed timeline that they were faced in this circumstance, it would not have been able to be.
And do you agree that both options he was provided would violate his sincerely held religious beliefs? He either has to eat a meal that is not compliant with the Ramadan fasting, or not fast.
Sure. So
Maybe.
commissary options were available to him as well, and I understand, and the point is
He's
well
indigent,
taken
right?
that he's indigent.
You're gonna give him, why didn't they, if there's commissary items available, why couldn't they use those to make a shelf-stable option for him to have during Ramadan?
Well, under Turner, it is the inmate's burden to propose
Right,
the
so,
alternative.
but you acknowledge he's indigent, but at the same time, you're saying he could have gotten these things from the commissary, when you know he could not have.
Well-
Logically, practically, because he's indigent, unless he's gonna go steal it, then we got a whole other issue.
Right. So that's a theoretical option. He could have chosen
It's
one
a
of.
theoretical option, is that sufficient to violate his sincerely held religious beliefs?
No, but there are also other alternatives to practice his religious beliefs available. I understand that the diet was an issue, but under alone and under this court's precedent in Firewalker Fields, the court also, as one of the factors, looks to whether there's also alternative means to exercise their faith. Here, Mr. Roberts could have attended services, he could study and religious text, he could have a prayer rug, he could have a Quran.
What's the primary religious tenet during Ramadan? Is it all these things? Really, I mean, they can do all those. You could do all those things during outside of Ramadan. You can read literature and all of that. But what about the fasting? And isn't that a core tenet of Ramadan?
The fasting is a core tenet of
No, I
Ramadan.
just don't see how reading pamphlets is equivalent to the requirement to fast or to eat an appropriate meal.
Well, given the logistical hurdles at the time, with 6 weeks' notice, yes, there was nothing available. There's only so many options that were available, and the Commonwealth's position is, yes, we recognize that this.
So you're saying that, yeah, I mean, the appellant was in a catch-22 with the options he was given, but you're saying that the prison was also in a catch-22 because it says that it couldn't accommodate.
Yes,
this.
and I think, Your Honor, it shows that VDOC wanted to do it correctly. The record shows there was another inmate that requested this at the same time. And if we didn't do it correctly the first time, I imagine we'd be here on a different circumstance where we gave food and people got sick and then got sued. So I think from VDOC's position, they wanted to make sure they did it right and did it well, and they have done for the past 6 years.
So that's an acknowledgement that they did it wrong.
At the time, there were logistical hurdles and safety concerns that they could not do it.
So they did it wrong because there were logistical hurdles and safety concerns.
Yes.
And the safety concerns were that he would get sick?
Yes, and the
Did
record.
he get sick anyway because he was forced to deal with the options he was given?
Yes, because he kept food that was not safe to consume for hours on end and got sick 3 or 4 times. VDOC wants to avoid that, but they need to be given the leeway and the deference to be able to do it right.
They actually tried to comply with what he wanted and he got sick.
No, Mr. Roberts was saving his meals throughout the day, his regular kosher meals throughout the day until after the fast was over, and then eating them and got food poisoning.
He was trying to comply with
Yes.
the time to eat, and that's why he did it, and it sort of forced him to doing that. And the point that Judge Thacker is saying is that while safety was a concern, it appears as though they created a situation that caused him to be sick. Whether it was his action and contributed to it or not, but if he's following his religious beliefs, a person who has a sincerely held religious belief is not going to eat except at an appointed time. And you have to know that. You know what he practices. He's not going to eat until then, so you know he's going to, if he's going to eat at all, he's going to have to hold it to that time period.
Yes, Your Honor, but I think that under Turner, the decision to not give him the food in the first instance was out of safety and logistical resources as well.
And what's the reason for not giving it to him at a later time, so that would be within a safe zone?
VDOC's position is that they did not have a meal available for that third meal that's given to go, that would comply with the 4-hour agreement. Inmates to participate in Ramadan have to sign an agreement that says, this third meal that I'm getting after dinner, I agree to consume it within 4 hours. So the food has to be stable and safe enough to last for that 4 hours. They could eat it as soon as they get it. They could eat it 4 hours later, but it needs to be consumed within that window.
But what I'm saying is, why don't you give it to them? What was the problem with giving it to him within 4 hours of when he had to break fast, when he would have eaten it, so it was within the time? Like, give the to-go meal later in the day.
Sure. The hot meals that were given for before sunrise and after sunset had to be consumed within 30 minutes. It is my understanding that VDOC did not have a bag option available, that they could give it to him at dinner that would still be safe 4 hours later to consume.
I know, why don't you give it to him 4 hours later instead of after dinner to go?
Well, I think that would create a logistical problem for VDOC in terms of timing and getting the meals out. That is like a human resources issue as well. And it's my understanding at this time that all of the meals were delivered specifically to inmate cells on the Ramadan schedule, especially because it's COVID at the time, so trying to minimize contact.
Now, you adopted Judge Thacker's suggestion that you'd done something wrong, or did you intend to do that? That you did something wrong? I thought you were trying to tell us you did the best you could.
We did the best that we could, Your Honor. I acknowledge the case law says that under the Free Exercise Clause, the prisoner has a clearly established right to consistent with religious principles, but the second prong of that is whether this policy is also reasonable under Turner. That alone is not enough, which is why we need to look at the facts of this case.
And Judge Jones accepted your explanation of what you'd done as being the best you could do.
Yes.
That's the district court that's being appealed here.
Yes.
And you're saying that you all did argue to Judge Jones that you could not create a new menu?
I don't know that it was specifically argued to him, but...
Okay, I didn't think it was, and I thought I heard you, at least I got the impression that you were saying that it was argued below. But this, we can't create a new menu in that time frame, was not argued below?
Mr. Engelke's statement, which the district court was attached to the Commonwealth's motion for summary judgment, specifically said that the menu had to be reconfigured. That's a quote, reconfigured. And I take that to mean that it's this fourth meal, that's the new menu. It had to be reconfigured to create something that was compliant.
Well,
and
let's address at least a threshold issue. Judge Jones did not address the Turner factors at all.
Correct.
And I think, if you will, discuss and parse between the differentiation of the claim under the Religious Land Use Type Act versus the First Amendment arising under Section 1983. It just seems to me, even with the religious and damages is what you're seeking, I just don't think it's available in official capacity. As I discussed earlier, it looks to me down the pipeline not going to be an individual either, unless the Supreme Court does something that surprises me on it, in the London case. But then you go to the First Amendment, and First Amendment is tough for a prisoner because there are very, very few rights that the Supreme Court allows, and when you view the Turner factors in that way. So what do? Do we send it back to the district court, because it did not look at the Turner factors, to do that?
No, I believe this court can do the Turner analysis itself. It's a question of law, and the facts are within the record for this court to
You gotta look at
at.
facts to be able to do that. Turner is law is Turner, yeah, it tells you to do it, but to actually do it is a trial court function. I mean, it just seems clear if you did not address it at all, and you mentioned Turner over and over and over, I've been hearing that over, and yet the district court never even mentioned it. I mean, so that seems to be there. And, you know, of course, as we discussed, even at the end of the day, you get there, then you gotta deal with the clearly established aspect of it, which really kind of separate questions in and of themselves, but at least from the constitutional perspective, it just seems like the Turner factors need to be addressed. Whether the result changes, I think at the end of the day, the Turner factors are strong. I don't know how you overcome those to establish that claim, but nonetheless, it should be addressed.
Well, this court can decide not to address the Turner factors and simply decide that the law was not clearly established to avoid a remand situation. And
Yeah,
here,
we know that. We've already discussed that part about it.
What
It doesn't help the law when we bounce away and duck a tough question. It doesn't help in terms of establishing something for the next time clearly established. In fact, it probably says go keep doing the same thing over and over again because it won't ever be clearly established. So you're telling us not to clearly establish if we believe there is a potential violation. But I'm not simply saying the remand is something that's potentially, but you said don't go there if we can affirm on the clearly established.
well, it seems like it would be somewhat of a waste of judicial resources to remand if the
Well,
Turner
what does the Commonwealth want us to do?
the Commonwealth wants this court to affirm the district court's decision.
To affirm Judge Jones across the board.
Yes, Your Honor.
Any way we can.
Short and sweet, right?
Short, sweet, to the point, affirm.
Short and sweet.
The injunctive relief claims are out. This has been moot, so there's no point to remand on that. That policy has been changed, and he's been getting the exact relief that he wants for 5 years now. The RLUIPA damages issue, Mr. Roberts filed a notice waiving that point. So on remand, that the no damages in their individual capacities is still, the Supreme Court hasn't decided. They've waived that issue. They filed a notice. And then on the free exercise clause, I think you just get into the clearly established prong.
There's no need for a remand. You're sticking with affirm.
Yes.
All right. So you've settled on that position.
Yes, Your Honor. If this court has no further questions, then I'd respectfully ask this court to affirm the district court's decision.
Thank you, Ms. Phillips. Ms. Selkis? Good to have you with us.
Good to be here, Your
Now,
Honor.
are you all third-year students?
We are, yes.
You're about to graduate, or you already have?
We graduate in about a week.
In a week?
Yes.
That's wonderful. Then you have to take a bar exam of some kind?
Oh, yeah. That's next on the docket.
But you're already trained. Professor Corson's already got you ready for that.
Yes, we're very much prepared, I hope. May it please the court, good afternoon, Your Honors.
Let me ask a threshold question just to be clear. When I read this, I thought there was a question of whether there was notice in June of 2019, and then you had the 2020, but if I heard correctly earlier, March 2020 is the date now that we settle on.
Yes, Your Honor.
So there's no factual issue. Is that true or not?
Not necessarily, Your Honor. The March 2020 date is important because that is what defendants are saying made it impossible for them to create this new menu, that by the time they realized, in their words, that Roberts required the OJKD on the Ramadan schedule, they wouldn't have had time to create this new menu. It was back in July of 2019 that he actually went on to the OJKD diet. But to Judge Thacker's point, this new menu argument and these logistical hurdles and safety challenges were not addressed at the district court below. This is an argument that they have now raised on appeal in order to create this rational link between their denial of Robert's request and between their denial of Robert's request and these penological interests under Turner. And I would like to point out that reconfigure is not the same as creating a new menu, and there's evidence of that in the record. For example, in Engelke's declaration, they say on he says on JA 256 that Robert's request to receive OJKD on Ramadan was denied because he signed an agreement for the Orthodox Jewish diet. It says nothing about this new menu or any of these logistical challenges. And in their brief, they define or they explain what creating a new menu would mean. And it would mean on page 9 of their appellee's brief, in order to create a new Orthodox Jewish menu.
And you, by their explanation of new menu in their brief, you mean here, because they didn't say any of this below.
Yes, sorry, apologies.
No,
Your Honor,
I
yeah.
just wanted to make clear
In the
that's
brief
the case.
to this court, they explained that creating a new menu would require them to consult with the Muslim and chaplain services of Virginia to design a new menu. And after designing it, they would need time to order and purchase the necessary food. That's how they're defining new menu, which is not how Engelke defines reconfigure or how the district court looked at reconfigure. The district court says that in subsequent year, in 2021, that the OJKD meals were just served on the Ramadan schedule. And that on page 257 of the record, Engelke says that when they finally did accommodate Robert's request, they reconfigured the OJKD such that Muslim inmates who had been on OJKD would simply continue to receive that menu or that diet on the Ramadan schedule. So conflating reconfigure and new menu just isn't accurate and is not reflected in their briefs to this court or in the district court opinion. Looking also at the district court opinion, the footnote that the district court cites in support of defendants' new menu theory is unsubstantiated. There are no facts in this footnote that actually support the claim that defendants...
What page is that on?
It is on page 417 of the record. And because the
By
defendants...
the record, you mean the JA?
Yes, apologies.
That's the joint appendix.
The joint appendix, Your
That's
Honor.
different than the record.
You're
You
correct.
might need to know that for the bar exam.
My apologies, in the joint appendix. And because the defendants didn't make this new menu argument before the district court basically speculates in saying that it would have required advanced planning, nutritional research, and other requirements. But there's no cite in that footnote to support that statement. And under a summary judgment posture where the facts must be taken in the light most favorable to the non-movement, they're basically taking the facts, such as in Engelke's declaration, in defendant's favor, which is improper. And lastly, Your Honor, looking to the first prong of the clearly established right of qualified immunity.
But what about the Department of Corrections points out that they wanted to do it correctly. They had been trying to accommodate, they had in fact been accommodating him since 2019, and then they were, and today I guess, still accommodate the Ramadan schedule. But they just, isn't that some indication that they just could not accommodate him?
Your Honor, not necessarily, because looking at the contemporaneous rationale for why they denied Robert's request, they say nothing about attempting or taking that month to try to accommodate his request. They simply just flat out say that the OJKD wasn't available for Ramadan. So at the time of the denials back in March of 2020, there's no evidence to suggest that that is what they were trying to do or that they were trying to accommodate him. And it would be improper to now speculate retroactively. But returning to the first prong of the qualified immunity analysis, as discussed, defendants are attempting to narrowly define the clearly established right to fit the exact factual circumstances of this case. And that's all Roberts is asking is for this court to apply. Oh, I see I'm out of time, Your Honor.
You go ahead and finish your answer.
Thank you. Roberts is simply asking this court to apply its own precedent from Lovelace and holding that he has a clearly established right to a diet consistent with his religious scruples. And this is not too high or too general of a definition. The court in Winfield v. Vass said that it was overgeneralized to say defendant had a right to personal security, and that would be as if Roberts was arguing he had a right to religious freedom, which is not the case. And so the definition in Lovelace is the appropriate middle ground in holding that he is a clearly established right. Therefore, Roberts respectfully requests that this court reverse the district court opinion and remand for further proceedings.
Thank you very much.
Thank you.
We appreciate your work. Good to have you with us. Good luck down the road. We'll come down and greet council and then adjourn for the day. Or we could adjourn for the day first.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.